Grand Rising, everybody. Welcome to another Operation Wisedome. Today is Saturday, June the 14th. I got a special friend in town. Go ahead and say hi, Troy.
Hi, y'all.
Yeah, my boy Troy is in the building. He come to visit me. We're gonna be heading back down to Oregon today, kind of vibing and chilling. It's kind of crazy because someone just came and a family friend dropped off. I don't know if it's a family friend, but one of my ex's friends dropped off the girls this morning, and first thing she asked me, she said, "How you doing?" I said, "I'm blessed." She said, "Oh yeah, why?" I said, "Cause God is good." Next thing she said, "Oh, you a church man now?" Oh,
Uh,
well, okay.
that doesn't have nothing to do with faith.
I'm telling you. So, just let it be known, man. Some people are not very happy, and they question your happiness, and
Yeah.
they question who you are and what you bring forth, but never falter and fail in that whatsoever.
Yeah, you
Um,
gotta be careful. You gotta be careful of the ones that break blessed into be blessed.
mm, mm,
Mm.
Jesus said to Peter that on this rock I will build my church, signifying that we, the people, are the church. The building's just a building.
straight up, straight up. I like that for sure, for sure. That building actually is the protection of the people
Yeah.
in and of itself, if you really think about it.
Yeah, we
So,
are the
man, we've had a
temple.
lot going on
Yeah.
this week, man. As far as just movement, developments. This week has been really kind of tough for me just due to the fact that I've had to catch up because I was in Kansas last week. So it was literally 6 a.m. to 11 p.m. days,
Yeah, it
almost
was
every day
fun.
this week. It was, oh, yeah, y'all coming out. Yep, we got to meet up with Wesley and Alira. They came out and had breakfast with us while we was in Kansas. And yeah, I know just a lot was going on last week and this week as well. Reference Quentin's case. It's been mentioned twice that I've run into at the event of your objections video. I'm referencing his motion to demand dismiss, which apparently was substantive and substantial. Is there a way to get access to that? I'm suggesting there is no need to reinvent the wheel here. I'm not exactly sure what you mean by reinvent the wheel or where that is coming from, the least of these. But again, this is Operation Wise Dome. I'm glad that everybody's in here. If it's actually your first time, could you come up and introduce yourself, say hello, where you're from, and just tell us about how you found Operation Wise Dome? Who all we got in here for the first time? I know someone's in here for the first time. The least of these?
Mm-hmm.
Mm-hmm. Why don't you come up, introduce yourself, at least of these? No?
I am not usually one for blabbing, but no, what I meant by not reinventing the wheel is if you've got it written down and like access to it, I don't see the need to reinvent that, is my point.
Oh,
I'm just
okay.
looking to get access to it. No,
This
I've been at this game. I'm 70 years old. I've been at this for a long time, and I just was bugging the AI folks a little bit about how to get in front of this without using Title 42. Section 1983 kind of things, and that's been interesting. But what I'm trying to do at this particular point is get my ducks in a row so I'm not panicking when it comes up. I want to be ready when I launch, and that's kind of where I'm at right now.
right, straight up. Well, since we already have Teresa in this bad boy, Teresa, I wanted to bring up Teresa because Teresa is doing some amazing things. She's been empowering herself by taking on herself, proper persona for quite a while now. Has been has been fighting. Okay, Okay, I'll come in just a minute. Okay, Troy gonna come look. Okay. And Teresa has been doing a lot of this battling all on her own. She's already done so much, like seriously, a lot. And her case is pretty egregious, and I think it dates back almost all the way to COVID. That these things have kind of happened, and she's been
Oh,
fighting for quite a long time. But the point is that she's never given up. She's never succumbed. And she's actually winning on several different levels, which is very empowering. And not that it matters so much, but I think it does a little bit. And she's a woman, right? So with all that being said, I think Teresa is just an amazing person, and I've been wanting to have her come on and speak for quite a long time. So Teresa, I want to introduce. This is Teresa, everybody. Teresa, come on and speak. I'm gonna give you the floor for a little bit because I know you got a lot to say and a lot of empowering words. So please feel free to start wherever you want and go as long as you want as well. I have no problem with it. So everybody, welcome Teresa.
Well, Teresa.
welcome,
Hello,
Teresa.
Hey,
Teresa. Come on
Teresa.
on.
What
Hey
up,
there.
Teresa?
Yes,
Welcome.
Thank you. So if people have not heard about my case, this does date back to July of 2020. So Cameron was correct. And that's when we were all in the depths of the pandemic. And my city council, well, actually, it was one man that decided that he was going to, quote unquote, close our beach. And that meant that they had set up a standing army to guard the entrances to all the entrances to our beach, Carmel Beach. And they had one police vehicle that was prowling the water's edge, ensuring that nobody walked out there to get to the ocean. So I didn't know this at the time, but it is in our California Constitution that the people's right of way cannot be blocked if they want to get to the navigable waters.
Right.
So anyway, I was infuriated when I saw what they were doing. And I called to the crowd to try to get them because there was a big crowd that had gathered behind the police tape and the beach was entirely deserted. And I went out there and I called to the crowd and I said, hey, we can't let them do this. The beach is a gift from God. The state doesn't own it. We have a duty to go out there and take it back. And everybody let me go out alone. And my intention was to perhaps talk the officers out of it. But there was another tourist that had defied the quote unquote closure. And 3 Carmel. So this was under the guise of protecting us from getting too close to one another and violating the 6-foot social distancing protocol. And what they wound up doing, 3 officers attacked the tourist from behind. And they slammed him into the surf. His head went underwater. He lost his iPhone. They arrested him. And then they came back to where I was standing. They thought he was my husband. He was not. And then they arrested me. And if there are people on the Zoom that have not gone through this, I know that we say arrested, but it is a humiliating experience. They bind your hands behind your back. They start digging into your pockets. They make jokes with one another, and you're the brunt of the joke. And then they dragged me and the tourist out to a jail 25 miles away. They took my fingerprints. The Monterey County Sheriff's Jail is one of the most dangerous in the state.
Mm.
And then they ejected me at 2:30 in the morning. And they had taken my mace, and it's an industrial area, so it's totally desolate. And it was very scary. And I had to wait until 5 o'clock in the morning to get a cab home, which cost me $100.
Mm.
So in other words, the cops did not give a shit about how you got home, if you got home. Then I was charged with entering a disaster area and selling and possession of a tear gas weapon for the mace that I had. And I was facing up to a year in jail. Then I went to the police department 6 months later to pick up body camera footage of the original arrest, and I got arrested again. And then I went on the warpath, and I filed a lawsuit pro se in June of 2022, and I had no idea at the time what was going to wind up happening, but I'm excited to tell you guys about it. So my main adversary was an attorney by the name of Jonathan Redford, and they had hired a firm from Southern California, a reputable firm. And I would submit discovery requests to Jonathan Redford. He was the only one that signed any of the documents, okay, except one, a small, irrelevant one. So I would submit requests for that. I tried to get that body camera footage of the attack of the tourist since February of 2021.
Mm.
And first the city attorney dicked me around and he sent me back a bunch of irrelevant codes and case law. And it took me a long time to unwind from how that was fraud. So I never actually got that body camera footage. Then I asked Jonathan Redford repeatedly for that footage, for the texts on their cell phones, the emails, and he would say, yeah, I'm going to get them to you. No, I've been so busy. Oh, no, I am going to disclose those. And then later he would recant. Then we would schedule meetings in order to hash out why he wasn't disclosing these records. And he would cancel on me last minute, over and over and over again. And it was really pissing me off because I didn't know what I was doing. I was pro se. I was doing this without a lawyer. And then he said, okay, well, we're going to have all of them disclosed by January 10th. Then January 10th would come and go, and I would get nothing. Then he would say, oh, yeah, we're going to disclose them by January 17th. And January 17th would come, and I would only get partial. So then I figured out, so I was really gunning for this attorney, and he was making me angry. So it was in February that I figured out that he had never formally appeared. And in federal court, at least in my court, the Northern District, it's Local Rule 5-1. It says every attorney of record must file a notice of appearance when joining the case. Okay, so they didn't do that.
And so that's you're speaking on California, right?
That's right. And so then he had to respond to that. And when he responded, he blamed me for not bringing this up to his attention sooner. And he never admitted.
Wait. Say that one more time. I'm sorry. Hopefully I didn't get confused on what you just said.
He blamed me for not bringing up his failings sooner.
Oh yeah, that's kind of like the cops saying you made me do it. You made me bust your windows, right?
Yeah, that's right. And he said, well, I just wasn't aware of this local rule, but I'm now on point. So he left out something critical that I wound up finding out a couple of weeks later. It was on March 14th, and I went to the Northern District's website into the attorney status tab and found out that Jonathan Redford was not authorized to practice law in that court.
Oh, whoa. Got him.
Pardon me?
Got him.
Got him.
I got
Yep.
him.
Got him.
So I filed a motion for reconsideration. And let me tell everybody, you know, I've communicated this to Cameron. Not that this needs to be said, but you cannot trust the judges.
Right.
Because for 2 years, I was having all these conversations with people trying to figure out where my judge was coming from. What was he asking me to do? Well, I'm going to adapt and try to, figure. Okay. So I filed a motion for reconsideration because he denied my motion to strike all of Redford's documents. Then I filed a motion for reconsideration on March 20th. And on March 22nd, so I said, and I included a screenshot of when Redford was authorized to practice law in that court, which was 1 week before, despite the fact that the case at that point was 578 days old. So Jonathan Redford had submitted 30 void documents into my case. And I told the court on March 20th, 2 days later, Judge Cousins granted Redford's motion to dismiss. Meaning he was, so this wasn't even my responsibility.
Right.
Okay. This was Redford's, his firm's, the clerk of the court, and the judges to make sure that he was keeping order in his own courtroom. Okay. So my judge failed. He took no action. He granted Redford's motion 2 days later. And on top of it all, he took pot shots at me. He said my claims of prejudice were legally unfounded. I was trying to deceive the court, and he denied the motion for reconsideration. And what he did, and I only figured this out, okay.
Narcissistic behavior.
Yeah, and they're all in it together against you.
Right.
Colluding against you.
Yeah,
under
so
color of law.
No doubt, no doubt. So I thought that he was there installed to protect my rights, and it took me a year and a half to figure out that he wasn't. So he denied the motion for reconsideration. And the way that he did that was he found a case that was unrelated. So he found a case, the judge, that was adjudicated under 12F, when what he should have adjudicated it under was Rule 11. Rule 11 is sanctions, signed pleadings, motions. The court must strike an unsigned document unless it's promptly corrected, meaning that all of the defendant officers, the guys that attacked the tourist, Carmel, the officers that attacked me later, all of their documents were unsigned. So
Jeez.
the court had a duty to strike, which is what I asked him to do, but instead he adjudicated it under a case that was totally unrelated. And I only figured this out about a month later. Pardon me, about a month ago. So I filed the motion for reconsideration. The firm withdrew Jonathan Redford, and it was right around that time that he wound up losing his 20-year partnership in the firm. So he's now with a new firm.
Jeez. Bye bye, buddy.
Bye-bye.
Okay.
It's
but
another got him.
another got him. And then the firm withdraws Redford and replaces him with two attorneys.
Okay.
One, Esther Teixeira, who she remembers to file her notice of appearance, but on it, it says, I am Esther Teixeira and I am authorized to practice in the Northern District Court, except that she wasn't either.
Oh my god.
She wasn't either. So the firm withdrew Redford and replaced him with an associate attorney that I think had been an attorney for 9 months, letting her make the exact same error. And I caught that again.
Damn.
Okay, then I file a judicial notice on Esther, and it winds up getting Jonathan. Okay, so I got 4 attorneys admonished.
Jeez.
Teixeira, the named partner in the firm, Steve Rothens, Jonathan Redford, and then another one, Sam Beaterwell, because he didn't show up for a conference. And then Jonathan Redford and his entire firm get referred over to the Standing Committee on Professional Conduct for remedial action, discipline, and investigation. And that investigation is still ongoing. So
Okay, wait. Pause point. Remember where you're at in your story right now, okay?
Okay.
Jack has a good question. Where do we find out if an attorney is able to be in that court or not?
Okay, I'm not sure about the state court. And I think this goes for California. It may go for all the states. There is a tab on the court's website for the Northern District. Anyway, it's called the Attorney Status tab. And you go there, you put their name in, and then it will tell you when they were admitted to practice on that court. Okay.
Thank you.
So, yeah, you're welcome. Okay, so the judge keeps covering for them, and he doesn't even acknowledge the unauthorized practice for 4 months. And the only reason he did it is because I wouldn't let it go. I was like a dog on a bone. And I kept saying, hey, what are we doing about all these unsigned documents, all these void documents, all this discovery that he propounded on me that he didn't have any authority to do? So what the judge winds up doing is he dismisses my case because I didn't comply with the discovery requests that were all submitted by Jonathan Redford. So it really pissed me off. Okay. And then the other attorney that they replaced him with, Thomas Fay, is also under investigation by the Standing Committee because they gave conflicting reasons for why Redford had sustained his unauthorized practice. He intentionally obstructed the settlement conference because I was trying to get everybody in the room so we could, the defendants themselves, so we could talk, we could just start talking about this.
Right.
Thomas Fay claimed he didn't know that it was an in-person meeting, even though we referred to it as in-person repeatedly in emails. Then he claimed under penalty of perjury that they had not been able to communicate with me and I had gone dark, despite the fact that I was immediately in contact with them.
Right.
He said that the defendant, Chip Rarig, was going to be convalescing on his back all week, which is the reason he couldn't make the settlement conference. Then I found out in a vlog that Carmel had done a week before that they were expecting Rarig back in the office a week that he was supposed to be convalescing on his back. So I had all this stuff lined up against Thomas Fay, and the judge in the lower court didn't acknowledge any of it. So they dismissed the case on October 24th. I filed a notice of appeal, which got dismissed about 3 weeks ago.
Okay.
And I'll talk about how I'm going to overcome that in a second. So I filed the appellate brief. Now I'm gunning for Thomas Fay because he replaced Redford and he took up the baton of being a wanker just like Redford. So I filed the appellate brief on April 28th, and I say Fay engaged in ex parte communication with the court. He perjured himself here. He lied here. He's under investigation by the standing committee with Redford. He withdraws from the case a week and a half later. Then I file another motion for miscellaneous relief where I detail everything that Fay did. I file a ton of bar grievances on him and all the partners in the firm, because according to the professional rules of conduct in the state bar, all the partners are not only responsible for one another's conduct, but certainly for their associates. Then their website goes down for 9 days.
Jeez.
It just came back up yesterday. And Thomas Fay has also dearly departed Carpenter Robbins. So it looks like he lost his job too.
Woo! Tough. You are tough. You are tough.
So that's where I am. Yes, the appeal got dismissed for jurisdictional reasons, and I completely freaked out when I found that out on a Tuesday
Ooh, I
night.
wish Tanawah was in here right now because he'd go over those jurisdictional issues with you. He's tough on that. Keep going though. I'm gonna see where he's at.
That's okay. I'm just about done. So I had an absolute mental breakdown for about 24 hours because I thought the whole thing was lost. And I would assume a lot of people on the phone are in the same position as I am, but it has been 5 years of constant research, 3 years with the case, many sleepless nights, thinking the whole thing is lost. I thought the whole case was lost. I was angry at God from Tuesday night until Wednesday. And then I spoke with one of my amazing teachers, and he said, oh no, you can file, it's a motion to vacate under Rule 60B. And because it's not in essence, the judge's order, his final judgment is technically void.
Right.
He doesn't want to admit that yet, but it's void because he didn't have the authority to dismiss it. So I've been working on the motion to vacate for about 3 weeks.
Okay.
Every day, finessing it, the language, pruning stuff out, sending it to people. I'm on the brink of filing that. And then what that will do is I have to go back into the lower court to file it. And then it retolls the time so I can file a new notice of appeal and get back in the game. And that's where I am right now.
So with your jurisdictional issue, what was the jurisdictional issue? Because our professional legal expert Tanawah Downing has arrived in relation to jurisdiction. And I wanted to just have everybody welcome Tanawah, by the way. Say hi.
Hi.
Yo,
Tanawah.
Tanawah.
Yo.
Yo.
Mr. Tanawah.
You guys are so awesome, man. Thank you so much. You guys are so awesome.
Okay, go ahead.
Hey, Cam.
What?
Cam.
Go
Yeah.
back and hit that that shared link I sent at the very beginning of this chat. All ready for this?
Okay. All right. So Teresa, go into the aspect of what jurisdictional issues you're having, and then we'll have Tanawah kind of see, what his take will be on it.
Okay, so in federal court, with a notice of appeal, it has to be filed with the clerk on by the latest the 30th day. I went to file 2 other documents into Pacer on the 30th day. And for the first time ever, Pacer would not let me file any documents. So I went into the post office the following Monday, and I thought that postmarked meant filed, but at least in the federal court, that is not what it means. It has to be received by the clerk on the 30th day. Prisoners can hand it off to the prisoner guards on the 30th day. So they're the exception to the rule. It does not, that is not the case with pro se litigants.
Okay. So you better make sure to
So,
have your shit on time.
yeah,
That's all that was.
and I thought I believed that getting the postmark meant that it was filed. And I have researched this. This is not the cases that I found in the Ninth Circuit. It has to be received by the clerk. And the judge was really, gleeful about claiming that he's deeming the notice of appeal not timely and it's fatal. And I don't think that they know that I know there's a way around this. So, but it's, it's okay. I wish he had done his job last year because I have other things to do in my life, like, make my stained glass panels.
Yeah.
But it will give me the opportunity to go back and perfect the record, continue to illuminate all of the misconduct and the errors and abuse of discretion that the judge pulled. And then I'll have the opportunity to go back into the appellate court. So that was a jurisdictional issue.
That's what's up. Well, first off, I want to say for getting rid of 4 different lawyers. Yeah, you're a boss. Everybody should probably unmute and say congratulations just for that, for all that she's accomplished thus far. That's crazy. Congratulations.
Good job.
Julie.
That's awesome.
Congratulations.
Good job.
You're an
That's the
inspiration
stuff.
and truly appreciate you.
Thank
That's
you. But
the stuff.
I want to be clear. It's only 2 attorneys.
Okay, too.
Okay. It's not 4, but the night is young and it ain't over till the fat lady sings and I don't hear any singing. So I don't know how many career casualties I'm going to have once this thing is over.
Good.
But the fact that the firm's website went down for 9 days is significant. And I don't know what that means yet. But they are still listing Thomas Fay as one of their attorneys. But hasn't been with the firm for a week and a half. So I don't, there's something fishy in Denmark, I think is the saying. But yeah, it's only been two attorneys.
Well, I don't know. When I hear things like that, as far as like 9 and numerology, I kind of try to pay attention to it because, of course, 9 is that 9 spiral, which is the Fibonacci, which is the golden ratio, which is magical number. But then if we're coming into it, you got the next step, which is 10, which signifies completion. So maybe you're coming into that aspect of completion here soon. Maybe you're on that last stretch. And from everything that you've been doing as far as being persistent, unwavering in your aspects as far as making sure that you get what you deserve, which is justice, is I commend you and I appreciate you so much as far as American to another American. And I just want to say thank you.
Oh, thanks. But I consider it an honor that I was called down there that day by God, because I know that God was angry, and I know that He knew I was going to be able to see this through, because Carmel Beach is a gift from Him to all of His children, and not just the ones that were wearing the smug officers that were wearing badges that day. And then a couple of days later in the Carmel City Council, all of the council members congratulated themselves on what they've been able to do to us, and they thanked us for cooperating with the beach closure. And let me also say that in the second half of 2020, our city council posted right in their agendas that if you sunbathed, if you brought a cooler, chair, or umbrella onto the beach, you were going to do 6 months in jail.
Jeez. Well, please. Lawsuit.
Lawsuit.
Lawsuit. Like, what? Are you kidding? Oh, shit.
And they had also promoted an event which happened just a few days before they closed the beach, you know, with this professed commitment they were saving us from ourselves. There was a packed an event in the city park.
Yeah, they're saving us from ourselves while banning ivermectin.
Get them.
Well, I didn't get. I've never said anything about how COVID was real or it wasn't real. I've left all that out. I've just been illuminating their hypocrisy and brutality because they clearly didn't care about us violating the 6-foot social distancing protocol just a couple of days before.
Or in the
And the
process of
judge
arresting
ignored
you.
that. Or the process of arresting me. And the officer that arrested me wasn't even wearing a mask.
It's just control
And
mechanism.
then the
Narcissist.
ugly troglodyte that put her hands all over me and took my belt off, which is so humiliating and enraging, she wasn't wearing a mask.
Wait, now a troglodyte, just by definition, I'm visualizing it, but I want to get further clarification. What is a troglodyte?
It's like an ugly, it's in
Pre-human? Like pre-human?
mythology. No,
Yeah,
they're like
yeah.
ugly little monsters.
Yeah,
It's
okay.
caveman. It's
Yeah, it's like
caveman, Cam.
Cavemen.
yeah, it's like
Yeah.
that pre-man type vibe. Yeah.
Yeah.
Okay.
And it's been really gratifying going on the new law firms' websites and seeing these guys that have been demoted.
Okay, and again, just to verify for if they are allowed to work in that court or not, what was the process one more time for everybody? Because I think that's actually important. I haven't done this, and I do want to do it.
Well, the notice of appearance you can see right in the docket, okay, for PACER. So, for example, I could see that Jonathan Redford had never filed his notice of appearance.
Okay.
Okay. And then if you want to find out whether or not they're authorized in that court, you go to the attorney tab, attorney status tab
Okay.
on the court's website.
Yep.
And then you put in their name, their bar number, and it will tell you when they're admitted to practice in that court.
Okay. Perfect.
Oh, and by the way, so I got arrested the second time at the police department for supposed failure to appear in court. This warrant that they said was out for my arrest. And then the two attorneys, Jonathan Redford and Susan K. Blitch, who both argued back in October, because I tried to get injunctive relief from the federal judge, meaning, you know, I reported to him, hey, all these shenanigans happened in the lower court. I'm not getting a fair shake. Can you intervene and help me to get rid of those criminal charges?
What happened there?
He waited, well, the motion for injunctive relief sat in the case for 5 months.
Jeez.
And he waited until my birthday to
why
deny
didn't you?
it.
Okay. Oh, to deny it. Well, why didn't you hit for an emergency on that, anyways?
What do you mean?
Well, why didn't you hit for an emergency ex parte hearing?
I don't know anything about that. I
Okay.
thought that the motion for injunctive relief, I was told I could get it from the federal court. And anyway, he waited until my birthday to deny it. But the most satisfying aspect of this is that both of those attorneys, Redford and Blitch, said, hey, don't intervene, judge. She did a failure to appear in the lower court, and those charges were legitimate. And both of those attorneys had actually failed to appear in the federal court. Neither of them had filed their notice of appearance. So they were accusing me of something that they legitimately did.
Narcissist.
And I called them on it. In fact, Susan K. Blitch swore under penalty of perjury that she was an attorney of record for Monterey when she was not.
Mm.
And I brought that to his attention a number of times. And he said, oh, no, your claims of prejudice are unavailing. Yes, Blitch was tardy, and I'm going to deny your motion. I mean, it's unbelievable the cover that this judge laid for his cronies.
Well, I mean, to be honest with you, I've had some late just recently on mine too with like Hood River, right? As far as late responses and then no responses, and then the response that's being given is so poor and lacking. Um, and I got literally denied on mine. And to me, it's like, all right, that's fine, because the facts are the facts. Right? We ain't even got to the facts yet. Let's get to the facts now, right? And
Yeah,
so with that, sometimes I will just say, okay, that's cool. But at least I'm bringing it up in the record to kind of show, like
that's
these
right.
people are poor in comparison. And they're literally through their own declarations, they were begging. Like, oh, we're sorry, we forgot, and we normally work state court, not federal court, which makes me even more in my mind think, well, I really do need to go check up on their status, right? Because if you
Uh-huh.
can't even understand that you have to respond after I file a fucking an amended complaint, like what? Like, come on. And I got to explain the rules to you as far as when and how I can file that amended complaint, whether I need to go to the court to ask permission or not, or whether I just have a matter of right to do it. Um, and
Yeah, I found that repeatedly that I think they have become so sloppy and lax, and they have so many rules. And then it is our job to call them out on not following their own rules.
Well,
Yeah.
that's a great segue over to Tanawah because they're not following their own rules at all. And Tanawah is probably one of the biggest proponents in this nation right now, moving forward in relation to that and holding them accountable for every action that they are doing that is out of step with the Constitution in every regard. Go ahead, Tanawah.
Hey, thanks for having me, guys. I appreciate the intro too, Cameron. And as you were talking just a moment ago, what was her name? I'm sorry.
That's Teresa.
Teresa Nicola.
Teresa. Okay, hey Teresa. There's a whole bunch of stuff that I would love to tell you about in what you're going through right now. But let me just start by saying that we have a system of government right now that believes that they're able to determine what is or is not criminal behavior. We have the same government entity that investigates what is or is not criminal behavior. The same government entity that charges you for whether or not you've committed that criminal behavior, the same entity of government that judges you as to whether or not you're guilty of that criminal behavior, and then the same government entity that profits off of your involuntary servitude once you've been deemed criminal under the criminal behavior. So there is no neutral, unbiased decision maker in this process when the state is the person that's bringing all of these issues, right?
Okay.
And so, you mentioned jurisdiction, you mentioned Civil Rule 60. What's most important under Civil Rule 60 is Civil Rule 60B4, because what you're trying to do is when you talk about jurisdiction, what you're doing is jurisdiction is the only thing that can void a judgment, nullify a judgment. And that's stated under Civil Rule 60B4. You see, 60 before, what it says that a judgment is either valid or it's void. It can't be anything else. It's either valid or it's void. And it says that it's valid in all instances except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction.
Wait a minute. How about, I've also read, pardon me for interrupting, but I've also read numerous times in cases that it is either that it lacks jurisdiction, or they have violated due process. Both of those can void a judgment.
Right. So it won't void it, right? So what the lack of due process does is that collaterally attacks the judgment itself. The jurisdictional issue, or the absence of jurisdiction, that negates and voids the validity of the court, right? Which means that there isn't a judgment. That's when it's void. But if you collaterally attack it, you go to the end and you appeal it, which is claims processing. You see, 2 years ago, the Supreme Court of the United States came out in a ruling where they said they said that the difference between a claims processing rule, which is an appeal, claims processing, the difference between a claims processing rule and a jurisdictional rule is that a jurisdictional rule can never be waived and can never be forfeited because it comes as a first duty to the court. So this whole jurisdictional animal is really quite simple when you consider the fact that we, the people, in our sovereignty, we created the Constitution of the United States of America, right? And through the Constitution, we created jurisdiction, because jurisdiction is the authority for a court to arbitrate an issue or speak the law. Absent jurisdiction, the court has no authority to do anything because the people didn't delegate that authority. So jurisdiction then creates the court, and then the court then creates the court's agent. So when you submit a challenge to jurisdiction to the court's agent, and the court's agent say, no, we have jurisdiction, that court's agent doesn't have the authority to make that determination, because jurisdiction is a creation of statute, which is what creates the court. Absent jurisdiction, there is no court, which means that there's no court agent, because absent the court's authority to be a court and speak the law, there can't be an agent that exists, because the delegated authority wasn't created and given through the Constitution of the United States. So when it comes to jurisdiction, you know, in order for a court to render a legally binding decision, it must have two things, right? It must have subject matter jurisdiction, and it must have personal jurisdiction. Subject matter jurisdiction is the right to oversee the type of case that's brought before it. So in the case of a death, you wouldn't bring that to a small claims court because they wouldn't have subject matter jurisdiction. To oversee the disposition of deceased assets, you'd bring it to a probate court, because that would be the court that would have subject matter jurisdiction. The second thing it must have is personal jurisdiction, which is the right to oversee the parties involved in the dispute. If the court lacks either one of those two things, then that court has no authority to speak the law. It has no delegated authority from the Constitution. As a result, that is not a court. Therefore, that's not a judge. It's not a prosecutor. It's not a CPS agent, because absent the court being able to create the court's agent, the agent doesn't exist. So as long as, if you go to the jurisdiction and you challenge the jurisdiction, you don't challenge it through the court that is you know, acting without jurisdictional authority, without lawful authority. You must go to the proper court imposed by law.
That's a big one. Wait. That's a big one.
Yeah.
Elaborate that on a little bit. That is very big, because all we are doing right now is challenging jurisdiction and literally getting nowhere. They're just bypassing us. So I talked about this last night in a conversation I had, and the thing is that a lot of people are correct, right? They're like, oh, the court doesn't have jurisdiction, but they're going to the court that lacks jurisdiction to challenge the jurisdiction. And what's happening there is that the state already has a law that forecloses upon your procedural situation, meaning that they've already decided that they're going to break the law, and you can't go to the tyrant and say, hey, stop breaking the law. You can't ask a criminal to stop committing crimes because they're a criminal, right? That's what they do. But so the first thing that you got to do is you got to go to the Constitution of the United States of America, right? Because the Constitution is what creates the jurisdiction, right? That's what the people created, that delegated the authority for any court to be a court in America. Now, you don't want to go to acts of Congress, because acts of Congress that are unconstitutional are still unconstitutional. You know, when I tell people that my degree is substantive law, I was trained in the substance of law, which is not adjective law. I didn't learn what attorneys learn because I learned a different set of law. But one of the things that I was taught, and I went to the most expensive university in the United States, I got a 3.98 GPA, graduated on the South Lawn of the White House. I know substantive law about as good as anybody in America. But the thing that I was taught that's most telling and most, you know, reserved in my mind is anything that is not the Constitution is unconstitutional. Right.
Simply by virtue of the fact that it's not the Constitution makes it unconstitutional. So there's this military combat philosophy. I was Special Operations Navy for 8 years. And there's the military combat philosophy that if you hold high ground, you hold a superior tactical capability over your enemies, right? So if the Constitution is the highest form of law, right? And being the highest form of law, when we get up onto the highest form of law, we have a superior tactical capability over our enemies. Now our enemies are going to draw us down. They're going to try to draw us down to the weeds, into case law and judge-made rulings and all this other bullshit that is not the Constitution, because that's where they win, right? But if we get up on the Constitution, the highest form of law, and we speak that law, what we're doing is we're drawing the enemies up to us, maintaining our superior tactical capability, because these individuals that are fighting against us, they can't fight at our level, because what they're doing is, of course, unconstitutional. So when you bring in a challenge, you know, the best thing to do is, the only thing you talk about is the Constitution, right? And so when it comes to jurisdiction falls under Article 3 of the Constitution. And jurisdiction actually, for the United States Supreme Court, right? I'm not talking about any other courts. And, you know, people talk about Article 3 courts. They're like, you know, these state courts, they're not Article 3 courts. You're absolutely right. They're not Article 3 courts, because the only Article 3 court that exists is the Supreme Court of the United States of America, because that's the only court that Article 3 created, right? That's the only Article 3 court in the country, because it's the only court that Article 3 created. And so when you go to Article 3, what it does is it gives actually two separate jurisdictions for the United States Supreme Court. One is original jurisdiction, and the other is appellate jurisdiction. Now, we're all very familiar with the court's appellate jurisdiction, because we invoke it every day, right? We believe that the court is a court of discretion, that we appeal to them as a court of last resort, and, you know, so on and so forth. And that's what we believe, you know, the Supreme Court is. But what we failed to recognize, because it hasn't been invoked since 1890, is the court's original jurisdiction. You see, what the Constitution says is, it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Now, original jurisdiction means that that's the court to act first, not the last court, right? No other court in the country can act before the court that has original jurisdiction. And that jurisdiction is, once again, statutorily imposed through the Constitution of the United States of America. So if the Constitution says, Supreme Court of the United States, you have original jurisdiction of any case in which a state is a party, then that means that it's the court that has personal jurisdiction anytime that a state is named a party in a cause. And so to understand the rationale behind, you know, the Constitution of the United States, to understand its original textualist purpose, we would typically go to three people, right? The people that wrote the Federalist Papers. In fact, Supreme Court Justice Gorsuch is saying that James Madison is the supreme authority for all things Constitution. And so if we want to know why the framers of the Constitution wrote Article 3 in that way, we would go and look and see what the Federalist Papers had to say about this. So James Madison wrote the Federalist number 10, all right? And this was November 23rd, 1787. It was the article titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And in that article, what James Madison said, and by the way, this is the earliest known reference to the modern day concept of conflict of interest. So listen to the words I say here and understand that this was the earliest reference that our framers made to the modern day concept of conflict of interest.
Okay.
So what he said is, he said, no man is allowed to be judge in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. Thus, if a state is the party, it cannot be the judge. A body of men are unfit to be both judge and party at the same time. So James Madison was pointing to the fact that that's why they wrote Article 3 the way that they did, is that a body of men that brings an accusation against you cannot be presumed to be neutral and unbiased to act as the judge against you. Therefore, original jurisdiction is removed from a state court if the state is a party, and is constitutionally assigned to the Supreme Court of the United States of America. And we know it's the Supreme Court because the moment that the Constitution was created, there was no state Supreme Courts, because they didn't exist until after the establishment of the Union. So it was referring to the Article 3 court, Supreme Court of the United States, if a state is a party. Now, maybe that's not enough, right? Maybe I'm still misreading or misunderstanding. Maybe James Madison was referring to something completely different. So let's see if we can find another reference to this within the Federalist Papers, and we can in the Federalist number 80, written by Alexander Hamilton, the
Okay.
second drafter of the Federalist Papers.
Okay.
Alexander Hamilton made two statements within the Federalist number 80 addressing this issue. The first thing he stated is he said that the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there's a dispute between a state and the citizens of that state, then the federal judicial authority of the Union must extend, which means that the United States Supreme Court has jurisdiction, personal jurisdiction. So that's the first reference. The second reference that Alexander Hamilton made in the Federalist number 80 was he said state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in his own cause or in any cause with which he has the least bit bias or interest. So again, state tribunals cannot be presumed to be impartial when they speak for themselves. As a result, Alexander Hamilton is pointing to the fact that a state cannot be both party and cause the same, or party and judge in the same cause, because of the obvious conflict of interest that exists. So now we've got two of the drafters of the Federalist Papers, two of the founding fathers, pointing to the fact that if a state is the party, the state may not be the judge, and it's assigned to the Supreme Court of the United States. Now, the third author of the Federalist Papers was a man named John Jay. John Jay was sick during the Federalist Papers and during that period of time of drafting, so he only actually wrote 3 of the Federalist Papers, but and there isn't a reference to this issue within anything he wrote, but he did become the first Supreme Court Chief Justice of the United States Supreme Court. He didn't make the reference within the Federalist Papers, but he did make the reference within the case Martin versus Hunter's lessee. And what he said in Martin versus Hunter's lessee is he said that the Constitution has presumed that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. Again, it's the case and not the court, because the Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So the state doesn't get to make the determination as to whether or not the Supreme Court has jurisdiction or the federal court has jurisdiction.
It's already there.
Because the jurisdiction existed prior to the establishment of that court. The Constitution created the obligation. Therefore, the state would be breaking the law if the state took action absent jurisdiction. And anytime that a state breaks the law in the pursuance of an outcome, now we're at the point of voiding the judgment, because anytime government acts unconstitutionally, what they produce is unconstitutional. There's a maximum law that says any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation.
Yep, all day,
Right,
man.
right.
That's
Yeah, the
beautiful.
moment that so the moment that you determine that there was a constitutional obligation, then nothing else matters. So if you could point to jurisdiction, and you could point to the moment that that court took action in a case in which it constitutionally had no authority to take action in, then that judge is acting without authority. He's acting without jurisdiction. In fact, he has an automatic recusal under Title 28, subsection 455. If you were to look at Title 28, subsection 455, which is the automatic recusal code for judicial officers, if you were to read it, it says that a judge, a judicial officer, and this is applying to all judges, all across the country, anybody operating under the authority of the Constitution of the United States of America, which is what state judges operate under, that authority, the delegated authority from the people, right? What it says that a judicial officer has a mandatory, non-waivable, self-executing duty to recuse themselves if, and scroll down here, if they are an officer of either party, right? An officer of either party. These are judicial officers of the state who just so happens to be a party in the cause. If he or his spouse or a person within third degree, that's item 5A, is the party to the proceeding or an officer of a party. These are judicial officers of the state who is the who is the accuser, the movement party in a petitioner in your case. It is the state of California versus you. And as a result, that is a judicial officer. Now that officer, that judge, has a mandatory, non-waivable, self-executing duty to recuse himself because he is an officer of the petitioner, right? He's an officer
But
by
how do they
Where,
uphold anything? How have they upheld any statute ever?
where has this man
So
been?
So the way that it's supposed to work, just so you guys know, the way it's supposed to work is we were supposed to have limited government, right? The purpose of our Constitution was to establish rights and limit powers. People have rights, government has powers. In some cases, the state powers are limited, right? In other cases, federal government powers are limited. In more cases, both powers are limited, but they're limited to preserve the individual liberties of the people. That is the purpose of our Constitution. So now we have an unlimited government when the state chooses to become the accuser and the judge because there's no separation of powers, right? The way that it's supposed to work, just so that y'all know, the way that it's supposed to work is if the state brings an accusation, the state can't be the judge. Therefore, the federal judge, the federal judicial authority must extend. The federal government must be the judge because they're not the ones seeking the enslavement of the individual. However, if the federal government brings an accusation, they can't be judge either because they have the automatic recusal also, which means that the state must be the judge. Therein lies the separation of powers. You have the state, the judge, according to Article 3, right? In all the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed, right? So if the state or if the federal government brings an accusation, state is the judge. But according to Article 3, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if the state brings an accusation, federal court is the judge. Now you have the limited government. Now you have the separation of powers. This is what the framers of the Constitution created, and yet we've lost this. But under the Federal Judicial Code, under Title 455, Title 28, subsection 455, remember, I just said that judge has an automatic, mandatory, non-waivable, self-executing duty. Self-executing, which means that you don't have to ask him to recuse himself. He has a duty to recuse himself, and failure to recuse means he is acting when he has an automatic recusal. And according to Hill versus United States Supreme Court, anytime that a judge acts when they have an automatic recusal, that judge is now warring against the Constitution and committing the crime of treason, because you cannot act without lawful authority to act because you're not a judge. You are a normal person.
Let me ask something. That code, I think, is 28455, right?
Yeah,
Doesn't that
455.
only
Yeah,
apply?
yeah.
Doesn't that only apply to federal judges and not state judges?
Well, this
State
Constitution
federal.
and the laws, this Constitution and laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby any in the Constitution or laws of any states contrary and outstanding. So no, Title 455 applies to every state. The laws of the United States were created by the central government. They were federated out to the regional governments for application administration. This is what I'm fighting. This is the litigation that I'm fighting against, is that what is the role of these states within our system of government? Are the states sovereign? Do they have the right to be able to pick and choose what laws within our central government that they want to implement or not implement? Because if they are, we're not living in a union, we are living in a confederacy. Because a union is defined as two or more non-sovereign states with a centralized governing structure. A non-sovereign state is defined as a state not complete in itself, subject to a higher government's laws. So if the states are subject to the Constitution of the United States, the laws of the United States, then they cannot be sovereign because we live in a union. However, if the states can say, oh, we're not subject to that because they claim to be sovereign, the definition of a sovereign state is a state complete in itself, not subject to a higher government's laws. A confederacy is defined as two or more sovereign states with a loose, decentralized governing structure. So the issue here is, are the states sovereign? And if they are, we live in a confederacy. If they are not sovereign, then we live in a union, and they are bound by the laws created by the central government as designed and as believed, and as every single American across the whole country believes that that's the truth. So these states need to understand that if you live in a confederacy, then we got a bigger problem, because Article 1, Section 10 of the Constitution says no state shall form a confederacy. So we have constitutional obligations that exist, codified in the Constitution, that are backed up and upheld by certain laws. And the reason why I mentioned Title 28455 is because it's congruent with the Constitution. I would never cite a law that would be contrary to the Constitution because that's unconstitutional. I will back up the obligations created or the restrictions created by the Constitution with the statutory code, as long as that statutory code is not in conflict. I will back it up by judicial rulings because as long as they're not in conflict, because they support the Constitution. But another thing is that we mentioned the conflict of interest. A state has a conflict of interest, a vested conflict of interest, if the state creates the laws, if the state investigates if you disobey the law, if the state charges you and accuses you of a crime through one of its agents, a prosecuting attorney, and then the state judges you as to whether or not you committed that crime, and then the state puts you into a for-profit business for the direct benefit of the state that we call a sweatshop in China, but a prison here in America. These states are making tens of billions of dollars off the forced involuntary servitude of the weakest, most vulnerable in our society by them simply labeling them a criminal. And that's permitted under our laws, under the Constitution of the United States, because most people believe that slavery doesn't exist because we fought a war, lost 1 million lives, and then we ratified the 13th Amendment, and it says don't have slavery, but nobody really took the time to actually read the words of the 13th Amendment because it doesn't say you can't have slavery. It actually says that you can, and it codified the legality of it within our foundational law, because what it says is neither slavery nor involuntary servitude shall exist except as a punishment for crime. So if you say except, it means that you can have slavery, but it must be as a result of punishment per crime, which means that we took something, we retitled it as something different, we changed it from a private institution to a public institution, and then we made the slave owner the state, because now the slave owner is responsible for determining whether or not they're a criminal, and once they do, they can force them into these for-profit businesses for direct benefit of the state, regional state constitutions. For instance, Article 2, Section 18 of the Washington State's Constitution says, Congress shall provide for the working of inmates in for-profit businesses for the direct benefit of the state. We have a financial incentive to criminalize people, right? To hurt them, to steal children so we can cause trauma in those children so that they grow up and act in an aberrant behavior because of the trauma we inflicted, so that we can create a self-sustaining reoccurring product that's going to feed into this system so that we can have prosecutors, judges, and attorneys make billions and billions and billions of dollars off of their illegal acts. And so now we need to get this addressed. But no, to answer your question, state judges are absolutely bound by the federal judicial code, because the federal judicial code was created by the central government and federated out to each of the regional governments for application and administration. Now, that is what we're arguing, because the states believe that they have the authority to do that, which they don't, but that's what we're going to litigate. But the question then is what about all the federal prisoners? Because every single one of the federal judges had an automatic recusal under 455 that everybody can read. We just read it. It's right there in front of you. So not one single federal prisoner is there constitutionally and lawfully, because the judge that rendered the decision was an officer of the United States of America who just so happened to be the petitioner, the moving party, right? We have a massive argument that we're preparing to argue that they're not going to be able to get out of. But, at the end of the day, we're trying to bring a massive amount of attention to this jurisdictional issue, because for 243 years, they failed to follow their jurisdictional limitations. And as a result, they have not been acting lawfully. They've been acting unconstitutionally, and now we have a very, very big situation where there's 2.9 million people currently in prison in America on direct facial constitutional violations, because these states believe that they have the power to eliminate any fair and neutral decision maker, remove and grant themselves jurisdiction in conflict with the Constitution of the United States, and then go out and make billions of dollars off of these people that they are hurting, right? And so we've got to address that. But again, so we have all three of the authors.
Wait. Take a pause. Y'all just say thank you to this blessing of God's gracious.
Yeah, you just changed everything, Tanawah. Come on,
Thank you, Tanawah. Thank you.
Why are we even arguing in court? Why are we just leading with this the moment we walk in, man?
Well, I appreciate you guys, but I got to say
This
that I
man
would
is
be
speaking
nothing.
fire.
I would be nothing without God. So all glory to him. I'm only a servant.
Amen.
He's given me power to do the things I'm doing. And let's thank him for it. I'm just a servant, please. So I appreciate it.
You my new big brother. You my new big brother.
Amen.
Well,
Hey, Christ said he would come with a tongue of fire.
You my
With
new
a tongue
attorney of
and a
fact.
sword of fire.
Wow, look at that.
Thank you.
Yeah,
So a couple more things I just want to add to this, you guys. One is the duties and responsibility of the prosecuting attorney, because you mentioned a moment ago, Teresa, that there was a prosecuting attorney on your case. And I want to say that if you were to read the duties and responsibility of the prosecuting attorney written by the Bar Association, what it says is that the prosecuting attorney shall prosecute all cases in which the state has become a party. Again, the prosecuting attorney shall prosecute all cases in which the state has become a party. So if there's, all cases, criminal and civil, in which the state has become a party. So if there's a prosecuting attorney on that case, criminal or civil, the state has become a party. And as a result, the Constitution says in all cases in which the state shall be party, the Supreme Court shall have original jurisdiction. This is written in their own code. Their own prosecutorial code says that if the prosecuting attorney is on that case, the state has become a party, civil, criminal, it doesn't matter. And as a result, the Constitution said, state, you don't have authority to be able to do it because state, you are bringing this accusation through one of your agents. And as a result, the same body of men cannot be presumed to be neutral and biased to act as a judge in the case. And therefore, he has an automatic mandatory non-waivable self-executing duty to recuse himself under Title 18 subsection or Title 28 subsection 455 because of the obvious conflict of interest that exists and the absence of jurisdiction because the Constitution has imposed the restriction upon the state of being able to be both accuser and judge in the same cause. So now, again, we talk about the maximum law that any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. So any time that government acts without jurisdiction, nothing that it does is valid, which is why, Teresa, you mentioned an appeal a moment ago. Yeah. And I want to ask you, what is it that you're appealing? Because there is no judgment. Because that court didn't have authority to create a judgment, therefore there's nothing to appeal.
I know. Well, I had filed, before I filed the notice of appeal, I had filed a motion to vacate all of his previous orders and judgments because they were void. And then he denied that motion to vacate.
Yeah.
So I did try that.
Yeah.
Prior.
So one of the things that we have to do, we have to get in the mindset of doing. I'll tell you about what I've been doing over the last couple of years here, so that you can understand. But you can't ask a scorpion not to sting you. If you play with a scorpion and it stings you, don't blame the scorpion. You knew what it was. It's your fault, not its. Right? If you play with a criminal, right, and you ask the criminal to stop committing crimes, you already know what they are. Therefore, playing with them or working with them is going to result in criminality. You already know that. Now, if you abide by the rules of a system that doesn't adhere to its own rules, then don't be surprised if they're going to break the rules, right? And so the thing is that we've got to get in the mindset where we cannot prevent these public officials from exercising their power. They're going to do whatever they're going to do, right? We can't prevent them from doing what they're going to do. But what we can do is we can show them that should they choose to exercise their power without lawful authority, without constitutional authority, then what they produce is unlawful because of their criminality. You see, the definition of a criminal is one who transgresses the law. If you transgress the law, you, by the very definition of it, is a criminal. There are different types of laws. Constitution is a law. Statutes are laws. Well, but nonetheless, if government breaks the Constitution, they broke the law, and that's a crime. It's the crime of treason, right? So all that we can do with these judicial officers is we can say, you know what? I'm going to draw a line in the sand. I'm going to show you what the law states and that you are clearly operating outside of those parameters. And I'm going to give you an opportunity to decide, is that how you want to be remembered, right? You can either return to established rule of law and obey that which restrains your power, or you're acting without lawful power, which means that you're acting with no power at all, because absent delegated power, you have no power. So what you got to do first is, and it sounds like you've already done this, right, is that you draw a line in the sand. You say, this is what the law states. This is what your restrictions are. Because remember, the 10th Amendment says that powers not delegated to the central government nor restricted by the state governments are reserved by the people in the states respectively. The Constitution delegates power to the central government, and it restricts power from the state government. A restriction of power is that you don't get to be the judge if you're the accuser, state. That's a restriction. So the 10th Amendment preserves this and says, state, you're restricted from your power if you choose to act without your delegated authority, without jurisdiction. And so the first thing that you do is you tell the judge, right? You don't even have to do it, though. Remember, the automatic recusal is a self-executing duty. That judge must recuse himself, and failure to do so means that he is acting when he has an automatic recusal. And again, according to Hill versus United States, that is an act of treason because he's warring against the Constitution, okay? But once you draw a line in the sand, if you are nice enough to do so, say, judge, this is your limitation. You do not have jurisdiction here. And I'm asking you to return to established rule of law. But if you do not, I already know what you are, and you're already done. You're cooked. That noose is around your neck, right? It's done. So that's how you move to other courts. That judge is already done. Everything that the court is doing to you right now is completely without force or effect. Nothing that it produces is lawful because it's all in violation of the Constitution. And you've been nice enough to even inform them of that, which means that everything that they're doing now is knowingly and willingly engaging in criminal behavior, the crime of treason. You see, before they could have said, well, this is misfeasance, right? Right, they're sitting here and they say, okay, I didn't know, I was ignorant. But now it's malfeasance, because now they're knowingly and willingly engaging in criminal behavior because you've informed them of their restrictions and their limits of the Constitution, and they have chosen to continue to act despite being made aware of such limitations. That judge is in a very...
Let me also say that it wasn't just that judge, okay? Because there were a number of times in July and August last year, I was reporting the spoliation, I was reporting the perjuries, I was reporting the violations of the rules, and I said, hey, judge, I am requiring you to recuse yourself off my case. So I told him twice.
Yeah.
He stayed the case. He said, oh, okay, well, I'm going to have another impartial judge come in and make the determination on the recusal. 1 week later, another judge, because I was only dealing with a magistrate Judge Cousins. Then Judge Casey Pitts, after 1 week, he came in and he said, hey, I have thoroughly investigated this case and found no sign of bias or prejudice on the part of Judge Cousins, in order to protect the integrity of the judiciary, some other bullshit. Therefore, your request for him to recuse is denied. He's staying on the case. So now I have two judges that are failing to admit that I've caught them stepping in their own pile of lies. So I just want to say it wasn't. And he also he talked about 455. And he denied, and you can correct me, but I think, isn't he supposed to recuse himself even if I don't file a motion for disqualification or recusal? Okay, so
like I said, it's a self-executing duty. And a duty comes before your challenge, right? Before your right, he has a duty. And if it's a self-executing duty, it means that they have to do it on their own. You don't have to initiate it.
That's what I thought. And so, in other words, Judge Pitts's order itself is fraud. I mean, it's really, it's and then I'll give you a floor back, but it's been not an easy path coming to terms with the fact that the federal judges themselves are against us, and they're clearly colluding up there. It's been very difficult. So
let me just bring a little bit of light to that, so we can understand, because this is a very difficult pill for this judiciary to swallow. They're going to have to admit once I successfully argue this to the United States Supreme Court, they're going to have to admit that everything that they've done and everything their predecessors have done, their entire careers have been completely without force or effect because they claim to be experts in the law and yet they never followed the law.
Wait,
That's not an expert in the law. That's a criminal, right? That's all.
they don't.
You're a
Right.
They don't
criminal.
want to follow the law, Tanawah?
Well, so
You
they
mean
believe that
they're
they have
actually
the law.
just? You actually mean they're just a clerk of the involved agency in which they're related to or involved with? They're just a clerk?
All that they are is an equal administrator of the laws that we create, not the laws. They have no role other than to equally administer that which the people created, right?
Man,
But but there's a concept called the doctrine of master servant. And in the doctrine of master servant, it says that a servant will perform mechanical duties on behalf of a master. And in the course of their duties, they will always side with what is in the best interest of their master. So when you have a state judge, that's a servant of the state. The master is the state, judge is the servant of the state. Therefore, we can presume or expect that under the doctrine of master servant, that those servants will always side with what's in the best interest of their state master. So we're going to see, judgments and actions of the judges consistent with what we see right now today. Now, the problem is that a federal judge is elevated out of the state. So they practiced in the state their entire career. They've got biases and prejudices that are partial to the state itself, that are partial to, because that's how they practiced law their entire career, right? And for them to accept or acknowledge that maybe their entire career has been a fucking lie, right? And a joke. That's a tough pill for these judges to swallow. But that's the reason why a district court judge, the federal district, or a Ninth Circuit Court of Appeal judge at that, right? That's why they are going to be partial and preferential to the state interests as well, because they're elevated up out of the states.
Okay, so
now,
wait.
There's
So
presumptions are always mentioned in them, Cam. I've watched a ton of Supreme Court stuff in the past few weeks, and they're always mentioning, well, there's a presumption. Well, the state has its presumption that we think their stuff is at least probably credible at the first moment of entrance. You know what I mean? Until we find out it's not. There's a presumption that what Tanawah just said. I've heard the justices themselves say it.
Yeah,
more than once. Is that right, Tanawah?
Well, wait. What I was going to say with Tanawah was, well, since you're already foreseeing some of the issues that may come up, what do you think is going to be your strongest approach on that, or what are some of the multiple approaches as far as where you're going to be heading?
So I'll hit that. Let me just finish the Dr. Master Servant, and then I'll answer your question, Cameron.
Okay.
So what I want to point out to everybody is that the Supreme Court of the United States, it's the only court that has a different master, right? Different master. All the state judges and district court judges, they are elevated up out of state. But the United States Supreme Court has a different master, and that master is the United States of America. 50 regional governments joined together that creates their existence, which means that if they don't preserve the union and act in the best interest of the union, they don't exist anymore. They lose their power. Therefore, the servant will always act in the best interest of his master. The Supreme Court will side with this in order to preserve their institution and the power that they have, because if they don't, then they have ceded their power back to the state courts. State judges are now more powerful than them. And I guarantee you, stroking these justices' egos, that's not what they're going to do. They have a different master, and their master is the United States of America, the preservation of it, because absent United States of America, that court no longer has any power. So under the doctrine of master servant, it's the Supreme Court of the United States that will be the only court in the country. And that's why our founders, identified them as the Article 3 court, right? Because their purpose is to preserve the union and make what's in the best interest of the union. And that means we're not going to side with state interests, because state interests would cede our power back to them, and we would no longer have a Supreme Court, because absent Article 3, Supreme Court doesn't exist. Now, to answer your question,
draw that back to the people. If it goes back to the 50 states, just make it rock solid that means we the people. Or do we the people actually share some of that with this colorable thing called the state? When it comes down, let's say it comes right to that moment, and the Supreme Court's making that decision, and the choices are all these things. What are we the people inside the states as it relates to how you just framed that? Are we still the sovereign and the true master? Or is it some voice out of the state that is neither one of us here on this call? So who's the master in that moment, bro?
So if their power cedes back to the state, the people will have lost. We will have
That's what I
lost because
thought. That's freaking what I thought. Yep.
yeah. So if the Supreme Court cedes their power back to states, now consider this, you guys. The Constitution of the United States creates the central government, right? Absent the Constitution, there is no central government because that's what created them. So Article 1 created the legislative branch. The purpose of the legislative branch is, according to Clause 1, Article 1, all legislative power is vested in Congress of the United States, consisting of a Senate and House of Representatives. All legislative power is vested in that first branch of government, the legislative branch. That's all power to make, amend, or destroy law. Because all law, that's what legislation is, all law, power to deal with law is vested in that first branch of government. Now, the second branch of government is the executive branch, and they are there to enforce the law. That's why prosecutors fall under the president. That's why attorney generals fall under the president, because they're there to enforce the law, right? That's their delegated authority by the people, is to enforce the law. So they bring the accusation or whatever, they investigate, they're the enforcement branch. But what the executive branch does is it does not create law, because all legislative power is vested in the legislative branch. What the executive branch does is it creates orders, executive orders, right? Executive orders. But an executive order is not a law. It's not. Only law affect the people. Orders can only affect those that the president can order, right? Orders only affect the members of the executive branch, because that's the only thing that he can order, right? Is his agents. So executive orders is not law. And we know that this was memorialized last year in Chevron. June 28th, Supreme Court of the United States came out and said, basically, right, and I'm paraphrasing here, but executive branch, for 40 years, you've been looking at the law, you've been saying that it's ambiguous and not clear, and therefore you've been writing policy and then going out and enforcing that policy against the people of the United States as though it's law, but you have no delegated authority to create law or amend law, because all legislative power is vested in the first branch of government.
Right.
So when the executive branch was doing that, what they were creating was unconstitutional. Therefore, last year, June 28th, the Chevron ruling came out, and the Supreme Court said, executive branch, you don't get to create, amend, or destroy law, because you can only deal with orders, and you don't have the delegated authority to create law. So that's the first thing that we got last year. What I'm working on now is we have another branch of government that does not create law, and that's Article 3. Article 3 is the judicial branch. And the judicial branch, they are there to administer the laws. They're the administrative branch. They're there to administer the laws. They don't create law either. They create rulings, judge-made rulings. But once again, rulings is not law, because they don't rule. Only law affects the people. Rulings only affect those that can be ruled over, which is why the corpus secundum, the attorney handbook, says that attorneys are administrative officers of the court. So if you're an administrative officer of the court, you work for the administrative branch. Attorneys work for judges. That's the reason why attorneys believe that what judges say is the law, because they're ruled over by judges. But the problem is, and what we're working on right now is, judicial branch, you don't get to create law. And so all this bullshit that you've been created, that you were pointing and deflecting and projecting to the executive branch last year, we're now going to hold you accountable, because you made a judge-made ruling and then you called it law, case law. And then you directed all the states that they follow your alleged law, but yet we didn't delegate any authority to legislate to the judicial branch. Judges don't create law. You have no authority to legislate. Therefore, all of your rulings must be removed, because rulings is not law. And yet, when you walk into a courtroom, such as you did, Teresa, you walked in the courtroom and you said, Constitution says this, right? And you point out the Constitution said it, and that judge said, oh no, this judge-made ruling over here says that you don't, therefore we're going to follow it, which means that it's not the Constitution that's the foundation. It's now judge-made rulings that's the foundation, because judges go to judge-made rulings as though it's law to determine whether or not your rights are violated, and that's not the object of which their fidelity is bound.
That one's actually really, really big, because we just had that happen in relation to Barnes versus Felix, where they said, where did y'all come up with this moment of threat? Who started applying this? Y'all just made up this rule and just started carrying it like it was y'all's own. Like, no, it's always been the totality of the circumstances. Get back to it and quit playing with us. And it's like it's always been known. It's not like this is something new. It's always been known. It's just the district started running with that moment of threat as though that's what they had established, and that's crazy. So that's that's perfect. Perfect.
Right. Now, like
How about Terry
this,
versus Ohio?
So there's elements of Terry versus Ohio that I like, but the problem is that Terry versus Ohio determines the validity of the arrest, right? Now the arrest comes after the jurisdiction. So, another thing that I wanted to point out to everybody, and you as well, Teresa, is that what you're doing right now is you are defending yourself. All right. And don't be offended by what I'm saying. I just want you to reflect on it and say, oh, this is right. So what's happening is consider sports, right? You have a sports team, one's on offense, one's on defense. When you're on offense, you're in the best strategic position because you're going to score. When you're on defense, you're in the worst strategic position because they're going to score on you. So what you're doing is you are now defending yourself against the arbitrary things that they're bringing to you so that they can have something to arbitrate. There's something to argue. They're saying a whole bunch of stuff that you're now defending, right? Which puts you on defense, and government wins when the people are on defense. So what I would recommend to you is go on offense, right? And you go on offense by accusing them of the crime that they committed against you and nothing more. Nothing. Because the moment that you put government on defense, that's where government loses, because government can never break the law in the pursuance of an outcome without making that outcome unlawful, right? So when we look at the Terry stop, the first thing we got to say is, does the police even have the authority to pull you over, right? Then they wouldn't if those police officers have no existence, because the courts don't have the right to be able to be both accuser and judge in the same cause. If you're pulled over in your car, right, that police officer is accusing you of committing a crime, but that police officer works for the state. Jurisdiction is removed. Therefore, the officer itself, Terry versus Ohio, is going into an area beyond jurisdiction. If we start with jurisdiction, do the states have the authority to create laws against the people? The answer is no, because that would mean that the state laws are more powerful than the freedom and liberty of the people, which was not what our founders and forefathers created.
Right. Because I got a pursuit of my life, liberty, and my happiness without being infringed in any aspect. And if any aspect of that is broken, diminished, or just a little bit of a nuisance, yo, man, we coming after that, because again, this life is so special. It is so blessed, or shouldn't even use blessed, but it is so amazing to be here in this moment and to have another violate me when I've never violated anybody. It's such a travesty, and our nation is so much better than that, man.
Yeah.
Yeah, that's why we call these rights unalienable.
Yeah.
No fees, no taxes, no registrations, none of that crap.
Hey, Steve, just real quick. Steve, what do you got to say real quick? You've been having your hand up for quite a while now.
Well, it's just I've been listening to Mr. Downing here, and he seems to bring up a lot of questions about our state's sovereign and that, and it always brings me back to the supremacy clause. The federal government has only got certain supremacy over the states on powers that were given to them in the Constitution, because the states created the federal government and gave the federal government the power over foreign affairs and certain powers within Article 1, Section 8.
Actually, let me just correct you. The people created the central government. The states were created by the Constitution.
No, the people created the states.
No, the people created the government, period.
Yeah.
The people created the states, and the states could not handle all of different issues such as weights, balance, money, immigration, and foreign affairs. That's why federal government was created by the states to handle few and defined powers in foreign affairs. That's in the federal.
Who's the states? It's the people that makes the,
The
states.
people,
The people are the ones that make the whole government as a whole.
the people are
Yeah.
the masters over the states, and the states created the Constitution.
No, the people
Limit
created the
government.
Constitution. We, the people, right, do ordain and establish the Constitution. It was the people
Yeah.
that created the government, the central government, right? We created the Union, and then the states existed before the Union, but the states gave up their sovereignty to join the Union and subject themselves to the supremacy of the Constitution of the United States of America. That's Chisholm versus Georgia, the very, very first case the United States Supreme Court ever heard, 1793.
Yeah,
Who
yeah,
holds the power?
exactly.
Who holds the
The
power?
people, the
The
people.
people.
Who created the state?
Cano,
The
answer that.
people.
Who holds the power? That like
people
where?
hold the
Who's
power.
the
People. The
Hey.
people.
master?
Hey.
But we're only
Calm
protected by
down.
a
And
piece
so,
of paper.
and so the
Yeah,
Constitution,
Cam, you're right.
even the 10th article says that the powers not delegated to the central government nor restricted to the state governments are reserved by the people. Now it does say the people and the states respectively, but the difference is that this is the concept of states' rights, right? And this is literally what we're fighting because everybody says, oh, states' rights, states have the right to do this, right? But the problem is that when you say that a state has rights, you're personifying the state. You're making the state a person because only people have rights. States' rights have always been code word for discrimination because it permits the states to treat people differently. But only people can have rights, right? Government has powers. The state has powers, but those powers are restricted by what the people created, right?
But
So
see,
they
it
don't
goes
have
even
unlimited
deeper.
powers.
But see, it even goes even deeper. Like when I look at it, I'm not even looking at it as rights anymore. My shit is like sacred liberties. Like I'm creator endowed, like the creator lives within me, just like he lives within you. Like that spark and personality is within all creation. I'm not breathing air, I'm breathing God. Like that's the ether. Like they took the ether out of the equation for a reason, for you not to realize how important and special it is to be here. But when you internally realize that, that aspect of knowing where you are by not knowing where you are, that in and of itself is
Can
so
you
big.
hear me?
Hold on. That in and of itself, yeah, we can hear you, Paul. Come on in. Yo, everybody, welcome Paul. Paul
Hey,
Unslaved.
Paul.
Everybody
So
up.
yeah, I wanted to.
What's up, Front Slave you in the house?
What's going on, fellas? I just want to comment on this because this is part of the rap that I do all the time. So this idea that our rights come from the Constitution, when the Constitution is a contract we're not even party to, and it outlines the idea that our rights come from God, right? So I think everybody's trying to focus on what's on the table that's been put on the table by other men and women instead of allow God to use us, right? And to sort of genuflect to that idea of God to take all these servants out of the equation, right? The more that we point to the Constitution for where we derive our rights, the more that they're going to point to it and the later amendments and use it to interfere with our actual power, if you want to call it that, and natural rights. So I think that's kind of step one is understanding our rights come from God. Your claim on record or conditional acceptance is good as gold, especially when there's no man or woman on the other side making a claim, which most of these court interactions there are not.
Yeah,
correct.
So if I
let me jump in here
Tanawah.
for a minute.
Hey, hold
What's
on.
our
We
what's
do-
our
wait.
preamble?
Excuse me. We do have special guests, so this this is a little bit
I
different.
agree.
Tanawah, go ahead.
I totally
And
agree.
then
I just
real
want to pop
quick,
this.
Cameron, real quick, Wesley, just real quick, because I just wanted to add on to that. Also, too, we have to go to U.S. Code to define United States citizen as it's defined there as a business or an instrumentality of the United States. And the United States is also defined as a corporation. So when we start interacting with these documents and we start citing these documents, just like I believe when we start citing Supreme Court decisions, you're talking a personification, as the man said, which means mask. It's another name for a corporate entity or a corporation, right? So that's, I believe, spiritually how we're getting caught up here. We're not going to source. We're going 2 or 3, 4 steps down the line to a manufactured conceptualization that holds no power because it's illusory.
Yeah. If I could, let me just fill you guys in a little bit about me, just real quick here. What one is that you said that we're not a party to the cause. Unfortunately, I am a party because I'm under oath, right? That I will support and defend the Constitution of the United States against all enemies, foreign and domestic. And so I am I am party to the cause because of that oath. That oath binds me to the corporation. When I took the oath, I didn't understand that that was true, but I have a self-executing duty under my oath to do the things that I'm doing. So I am actually a party to the Constitution. Now, there was the movie called The Postman with Kevin Costner. And if you remember, in that movie, you could only challenge, the leadership by having the tattoo on your arm, tattoo 8. You had to be part of the corporation in order to challenge the corporation. I'm your inside man, right? I'm a part of the corporation. I can't get out of that because of the oath that I took. I am a party, but I'm a party that's going to be able to come in and do certain things that non-party members are not able to do because I'm able to challenge the leadership through that association that I have, right? Whether I'm meant to do it or not, God's put me to where I'm at, and I am a party to it, for one. Now, the other thing is you mentioned the business. And a lot of people are going around saying, oh, a person is a corporate entity, right? That's what Black says. And that's true, although the corporation was created by the person. What you're reading is actually, it's a decision that the Supreme Court made in 1882 in a case called Santa Clara County versus Southern Pacific Railroad, where they granted personhood onto corporations, and now it's become convoluted. But the reason why the Supreme Court made that decision in Santa Clara County was not because corporations need to be considered people. It was because under the 13th Amendment, the slave owner became the state, and the state needed to protect its slave industry, right? So the Supreme Court said only people can own property. Therefore, we've got to make the state protected from interference of its property, the slaves themselves. Therefore, they granted personhood onto corporations under Southern Pacific Railroad, but they did that because they wanted to protect the slavery institution and the slave owner, knowing that states are nothing more than a corporation. And when the state became the slave owner under the exception clause
Sure,
of the
but
13th Amendment.
that's my point, is if you go to court to this day and you walk in there and you don't establish yourself, right? I don't know if folks are aware, but I've been to court, at least a half a dozen times. I've gotten dismissals not only for myself, but people around me. If you go to court and you walk in there and you don't establish your standing or status, they're going to presume you to be appearing as a person, and they're going to then have a prosecutor who is actually a state actor stand up and claim to be the people. Right.
Well,
So this is one of the dangers of using these collectivized terms and systems. Is if you make yourself a party to it and you swear to it, then you're bound by it, right? One of the benefits of being a man walking with God is we're fluid and dynamic. We can't be bound or latched or interfered with in our momentum, right? Our energy and motion. So I don't disagree with you. Go ahead.
And so what I'm doing is I'm challenging the person that's called a state, because that person they've acted as though they're a person, right? They consider it like this, that I'm a person, and I have a whole bunch of different parts. I have hands and eyes and ears and a mouth and legs and all these different parts that make up this one person being me. If my hand goes out and it steals something, my head can't say, oh, it was my hand that did it. You can't punish me, because any act unlawful by any member of my faculty, my whole body, my whole person must pay for that. So when the state decided to personify itself and bring an accusation against me or you or anyone else, it's acting as one single entity with a whole bunch of different parts.
Sir, not only am I aware it's acting as one single entity, but it seems to be a spiritual entity first that manifests in this reality as a physicality. So you're essentially talking about, from the beginning of time, what would be called a shaitan, right? Or the shaitan, the god of this world. So this is my whole point, is that let the dead bury the dead, come out of her, my people. If you're not in and of Babylon, then you're not of the lie, and therefore you cannot be governed. So the answer is not challenging the god of this world, but taking yourself out of this world, being in it but not of it, right? In the sense of how we stand and how we move forward, because ultimately this system is spiritually ordained, as the scripture kind of lays out. I'm not saying that this is what could happen or should happen. I'm saying this is what is happening because of what's not happened. And what's not happened is men and women who call themselves God's people on God's country have not stood properly on who and what they're meant to be and moved properly at the court. So they're not recognized, right?
Right.
They're now being recognized as one of the children of the lie, right? A person under a person.
Yeah.
Corporation means the speaker of the dead or the underworld, right? And that's exactly what the average American has become, a United States citizen instrumentality of the corporation, the speaker of the dead underworld.
But what are they lacking? What is the only thing? But wait, what is the only thing that they're lacking? What is the only thing that they're lacking?
A connection with the living God.
Not okay. Maybe.
Hello.
Okay, well, we could tap into that too. True. Yes. But I believe it's just knowledge. It's just
this is why the man asked before. Everyone's always arguing this idea of sovereignty. Oh, do we have our sovereignty or have we not retained it? You've never been the ultimate supreme power. That's God. The problem is folks have stepped in for that, and you've given all your time, energy, attention to the middleman that stepped in for that, the God of this world. Right?
So under the Torts Claim Act, right? This is what sovereignty.
Everything I say, he's gonna have an act or a bill or a code.
No. Because my boy, if you haven't been listening, he's been in here for a while tapping in, and what he's explaining essentially is the aspect of what he's been doing, bro. It's kind of crazy because when you understand that he's literally, up in the Supreme Court about to really argue this whole aspect, which is original jurisdiction, and how there's like 2.9 million people locked away for things that are completely against what he is doing. It's a pretty big fight, and he's really out here every day. I don't know if you know about Tanawah, but like he's out here every day touring, and he's
oh no, I'm not saying he's not active. I'm saying I notice this pattern of when I talk common law and common core understanding of who and what we are as an I am that am. It's like who we all are is we can't help but to go back to what's written down and what's been like passed down or what's been ruled.
But why is that? Why is that rather than just setting the precedent right now here forth?
Well, this is my point is, and I may be doing it a bit sort of as usual rudely, or I may just be being arrogant and I'm missing something and there's something I need to learn. But I believe the core of it is that we just typically in these situations don't trust God and trust ourselves and the word. And we always have to go to something in and of the world that seems more legitimized, but thereby delegitimizing who and what we are as God's people, right?
So true, yeah.
So I as the creation of God am about to walk into Supreme Court and challenge 47 creations of man that have personified themselves and demand that they come and refute the argument. The state has no ability to speak, right? I've served 47 state attorney generals with a notice that they're acting unlawfully and unconstitutionally. I've served 47 state Supreme Courts with a notice that their agents are acting unconstitutionally. Now I've notified the entire body, right? Because it's one person that they claim to be.
But you recognize they don't believe that. You believe that.
It doesn't matter what they believe. What matters is
of course it does.
Okay. Well, it doesn't matter because they came against us, and now we are going against. I, as a living creation of God, am going against that which is not of God, and we're going to destroy that which is not of God, because we have the authority under the Constitution of the United States, and that's what I'm invoking at the Supreme Court. And I'm going there with over 2 million criminal affidavits of people that have had these happen. We have. Cameron,
this is one of my concerns, right? One of my concerns is that you just spoke out loud what would be considered to Shaitan physically or metaphysically to be an act of war you just declared. So
no. It's not an act of war.
He just said he's going to destroy what is spiritually ordained that is meant to test and challenge God's people to serve God and stand on truth when they continue to live in and of the world.
Yeah.
So saying it's unconstitutional, I think is lacking the depth of understanding spiritually how this manifests. It's not unconstitutional. They don't believe that it is. And it's not because of certain clauses and the way that it's applied. And the more you keep citing it and making yourself a party to it, the more they know that you're meant to be ruled. Because those who are not meant to be ruled go to source, right? They don't cite man's creations, man's words, man's replications. They
No,
go to
you're right.
source.
No, you're
So
right on that.
so
But in this realm, what he has to do is he has to speak in this manner just to help the people that are currently caught up in the system. Deep down in his comprehension and knowing, believe me, I know Tanawah believes the same way that you believe. It's just we have to it's like we're trying to demystify everybody, bro. Like there's such a spell that has been cast upon our whole nation that it has to be done in steps. You want to go straight to the source. And yes, we believe in that same source and comprehend and know that source within us. But nobody else knows that on the surface level of things,
And
bro.
that's exactly the whole point of ministry and fellowship is that folks cannot be self-governing if they don't know that or have that connection. So they're absolutely meant to be ruled by statute, policy, code, and the deceiver and the accuser.
okay. So
That's their
let me
lot in life until they get where they need to be.
let me ask you a question then. So you said that your rights come from God. Is that right?
Sure.
Okay. Sure, yes or no? Sure, is not sure.
Absolutely. Affirmative.
Okay, so your rights come from God. However, the Ten Commandments, those aren't rights. Those are duties, right? It doesn't say that God didn't give you the right to live until the duty was established, thou shalt not kill. Thou shalt not
Correct.
kill doesn't say you have the right to live. Thou shalt not kill is the law, a statute that God gave to the people that said, now you have the right to live because the duty exists. So you don't have your rights. Those don't come from God. The duty comes from God. The duty and obligation to not kill someone comes from God, and that's what creates your right to live. In the natural state of man, you don't have the right to live because only the strong survive. In the natural state of man, you don't have the right to keep your property because in the natural state of man, only the strong survives. Thou shalt not steal is not a right. Thou shalt not steal is a duty that God created, which creates the right. And the right exists as a result of the law. Therefore, we must rely upon the law because according to scripture, God is the giver and creator of law. The law is what creates the right and preserves it. Yes, the right exists. God wants you to have your life. God gave that to you, but it's the law that preserves your right. Therefore, we have to fight from the law. That's the same thing with the Constitution because you don't have the right to liberty unless the law states thou shalt preserve your liberty. Right? And thus the Declaration of Independence. You don't have the right to confront the hearsay accusations against you in a fair and neutral decision maker because only the strong survive. We must create a law that says you cannot be held to answer without an indictment by a grand jury. These are the laws that were created so that we can have the rights preserved. Therefore, we must attack the duty to manifest the existence of the right. We can't claim, oh, God gave me the right to liberty because the liberty derives from someone's obligation and therein lies the law. So we got to start with the law, show that someone has an obligation. You can say however you want, but the obligation exists. Thou shalt not imprison someone, right, and enslave someone. We must show the law before we can say I have the right to be free. The law is what creates or what preserves the right. Absent that, just like Teresa was trying to do, she was mentioning injunctive relief. You can't claim injunctive relief until you show that someone had a duty, an obligation, and they broke the law. They broke the obligation. They breached it. Therein lies the answer to these issues. God gave the law, and the law doesn't create a right. The law creates a duty, and it's the duty that preserves the individual rights of the people. Right? God wants you to have your life, but in order to do that, he must give a law. And therefore, we must attack the duty, right? Which is encased in under
Well,
the
that's what
authority
an
of the law.
American is too. If you really get down to the depths of what an American is, that's one who has a duty morally, with integrity, honor, to uplift his fellow brethren. Like that is America. That's always been America. When you tap into that, it's a duty, it's a responsibility. It's like yo, man, it's all here. It's just, are we being that manifestation of what we know an American is to be? Still to this day, is that at the forefront, coupled with gratitude? Because that's what it, like, gratitude it comes in multi ways. Love, and bestowing that love is the greatest gratitude you can show, not only to yourself and to your fellow brethren, but to God and nature in and of itself. So that's what I say, like law and all of this. I see like Jack was like, I thought we're supposed to be talking about law, but that is the law. Like God is the law. Reality is the law. It's manifest in everything that we do.
Right. Absolutely.
Right. That's why that's kind of why I'm saying that I believe the remedy or the resolution is a spiritual one before it manifests as a physical one. And it does not pertain to the inside of a corporation or corporate endeavor, right? It can, but it shouldn't have to. And the moment that it has to, it's in a sense blasphemy, right?
So Paul says that we are, don't you know that you're all the body of Christ, all working together, right? So we're all the body of Christ, right? And what is seeking to destroy us? Well, that would be that which is against us. What is against us? The last thing that I wrote in the very last motion that I ever submitted to the United States Supreme Court, because I refuse to work within their rules and parameters anymore. But the last thing I wrote to the Supreme Court in the very last motion, last paragraph said, every single thing that I'm advocating is consistent with God's divine attributes. Release of prisoners, return of exiled captives, love in lieu of hate, compassion, not condemnation, forgiveness instead of vengeance, equity, and not tyranny. I know what side I'm on. So ask yourself, if I fight for God and you fight against me, who is it that you are fighting for? Right? Everything that court advocates for is contrary to what God demands. God says release the slaves, they say, oh no, they're our property. God says bring them out of the darkness, they say, oh no, they're going to be in a dark cell. God says lighten the yoke of those that work for you, they say, oh no, they're our slaves. Everything that this system advocates is contrary to what God demands. Therefore, I know exactly what side they're on, right? Which means that they are against us. They are anti us. They are, and so as a result, right? Now we can see what they are, because it says we're not, our battle is not against flesh and blood. It's not. I'm not fighting these judges out here at the level. I'm fighting the spirit in the high place, that high court, and the spirit of deception that they're giving to all the people. They're deceiving the people because we know that every single one of them is a liar, because that's the effect of perjury. They are all filled with the spirit of deception. I am fighting this from a spiritual perspective, but it's a spiritual perspective to manifest into the reality, because I know exactly who it is that they're fighting for, and it sure the hell isn't what I'm fighting for. Therefore, I already know the outcome, right? I already know that they're deceived. A lot of people have said,
it's crazy. It's crazy that we're fighting for unity. It's crazy that we're fighting for love and compassion. It's crazy that we're fighting for empathy. It's crazy that we're fighting for people not to suffer and be harmed. Like, what kind of like literally, what kind of reality are we in, bro?
Right. Is that not a deception within a deception? Because you just use the term fighting for.
If you believe in God, you know what reality we're in. We're in a spiritual reality, good against evil. Okay, that's what it boils down to. Is there's nothing in between. You're either good or you're evil. Okay, and that's the reality. So that's our biggest battle right here, and it's the bar association.
Yeah. I really want to bring it back to the beginning, because I really appreciate all of these talking points, but this is spellcast bullshit. We have to go back to the language, because they have basically inverted and perverted. They created this language that they use from the very start. They're trying to get one of the people, a living, breathing man, woman, to identify as a legal fiction using the word person. Every single definition of an individual, a child, goes right back to that word person. It is not one of the people. So if every statute, code, and all of that is talking about something that is not flesh and blood, we have to immediately, because that right there, they don't have personam jurisdiction. From the very get-go, you walk in, who here has a claim against me? They're trying to get you to utilize identity and identification. Again, those refer to legal fictions and persons. A living man and woman does not have an identity. You either recognize me in front of you, if there is an actual claim, nature and cause for which a relief can be granted, you need to bring it. Otherwise, you don't have a case. It's all fraud on its face.
And this is the point: when you recognize the reality as the reality and stop claiming I'm good, they're bad, that's part of the deception. Doesn't everybody think that they're good and of God? Isn't the thematic here that the majority, if not all, are deceived to some extent? So once you witness and testify that this is what it actually is, then the simulation collapses or changes form, it would seem. So,
yeah, because the other thing is they're already, I mean, like you say, you're walking in there, you're dealing with a judge, doesn't even look at the case or you walking in. They're all colluding and conspiring to defraud you, period. And it's all money.
But even that's a presumption and assumption. If that were the case, then myself and many others wouldn't be able to get dismissals. They'd have tried their damnedest to deceive and defraud and move the case as a third party impartial element of the court. And guess what? They haven't done that all places, all times. I'm not claiming it doesn't go on, but it starts with this idea that everyone here is good, everyone there is bad. We have to fight for empathy. Like, what does that even mean?
Well, we have to take the fight out of it. We have to put.
That's the point.
Yeah, but that's what I'm trying to say, though. So when you're walking in there, and the first thing you should be asking is, who here has a claim against me as I stand here? And you're the only firsthand party to this alleged offense, right? I'm not here to defend. I'm not here to even argue anything. I'm here to set the record straight that this court, if the judge cannot see me in front of them and can only see and hear fictional characters, legal names, persons that are imaginary and created, that makes them incompetent.
Lana,
right. It's not a government of and by and for the people at that point. And that's precisely what I'm trying to get across, that we're trying to fight inside of a dynamic that's not actually made for God's people, proving why it needs to be there for you to be tested.
Paul, to that point, and Lana, if I may interject, and this is also a question for Tanawah. For example, if I walk into court for this divorce proceeding that my corporation started, the all caps name, that the state is going to claim that they have jurisdiction over, if I, the living man, walk in and say, hey, my First Amendment right was breached upon by the state because it was turned into a contract, and it's monetized, the state gets unjust enrichment, or they get to rip either my or the other party's property, because technically it's me versus her, right? The state technically is going to claim that they're not a party in that contract, but yet they have authority over that contract, right? If I, the living man, walk in and claim that they were not supposed to breach my First Amendment right to relationships, to property, to all of these things, the state is still going to claim their authority over that corporation, the all caps names of both parties, whether I'm the living man walking in there or not.
Because you just cited the contract or the document that you're not a party to and claim that you get your rights from a constitutional contract or piece of paper. And within that contract and constitution are amendments, and those amendments are interpreted by legal interpreters. So they get to outrank you in how that document gets interpreted. They will always be infallible and correct and true, even if they disagree with each other.
That's not true. So the Constitution is not interpreted by the judges. Those are what's called per se. The Constitution is per se, and per se the definition is self-evident. The people are the ones that interpret the Constitution because we are the authority that created the Constitution. We are the sovereign, and the sovereign determines the law. Now, judges believe that they do it because judges have led us astray ever since the Marshall Court and Marbury versus Madison and all these other judicial philosophies that permeated into America from the English bar. Because, you know, we saw a massive influx then, because in England, you do have a sovereign, a king, and that monarchy. In the monarchy, he creates all the law. And in England, that king delegated his authority for his agents, the judges, to speak the law. So in England, judges do create law because the king delegated that authority to them. But Marshall brought in this English judicial philosophy back in the 1815 or 1818, you know, right after we were established. He brought in the judicial philosophy that judges interpret the law, that judges speak the law. And thus you create a judge-made ruling and you call it law. But the people of the United States did not delegate the authority for the judicial branch to legislate because, once again, Article 1, Clause 1 says all legislative power is vested in Congress of the United States. But you know what I'm trying to get to here is that
a Congress is a board of directors for a self-defined corporation called United States. That's U.S. code, right? U.S. code 1A. United States is a federal corporation. So then any constitution of United States is a contractual document referring to a corporation and a corporate process. Why would I want to take myself out of original status and standing in jurisdiction that is supreme and diminish my capacity, status, and standing by moving inside of a corporation and corporate endeavor and arguing statute, policy, and code, which can never be law? It's given the force of law through the consent of the governed. That's Declaration of Independence, Bill of Rights.
So how would you
because
go
if
about
you want to help other people overcome it.
forth like that?
What is he saying? I want to know what the reason why I should diminish my original capacity, status, and standing that works over and over again because they can't recognize man and woman at their court and they're asking for a person to appear. So when I make the conditional acceptance that I am not a surety for the all caps name, in quotes, I am in fact a man here today to settle all debts honorably and to compensate any man or woman who comes forth with a valid verified claim. If no man or woman comes forth with a valid verified claim, I require the case to be discharged. So they already know what I'm doing. I don't have to argue. I don't have to fight. I don't have to even disagree with them. I don't have to overthrow their spiritually sound governance that's there for the devil's people who are children of the lie, who are deceived already. I don't have to fight that or overthrow that. I just have to declare who and what I am and what I'm aligned with, and they will give me safe passage. This is written about in Lord of the Rings and pretty much every major pop culture film. It's put in there. This is the devil's world. You can't overtake it or overdo it. All you can do is testify and bear witness to God, and the devil will give you safe passage like the Eye of Sauron. Because
every
we're
time I've done that, I've been
and
thrown
what's his
into
name
Tifto.
carrying the ring?
So if your path is to save yourself, brother, I would welcome you to that path. My path is to save.
that's
No, hang on.
I know what your path is, to try to be a hero and a leader and save others who can't save themselves because they're not aligned with the word.
You asked
we
me
don't
a
need
question.
another daddy.
Listen, you asked me a question. I'm responding to your question. Okay. My answer is that the reason why I'm doing it is because my obligation is to help the people of the United States and those below me. Even if they don't know that they need help, that's my job. That's what I'm doing. And that's what I'm going to continue to do. And you're welcome to save yourself. But I'm not on that path. My path is that there are 2.9 million people currently caught up in the system that need a way out, and that's what I'm here to do. My purpose is that there's 12 million children that have been stolen from their families, right, and have lost the love and care that they need to become the person that God created them to be because the states believe that they can interfere with the familial unit. My path is to help them. That's why I'm doing this, and that's my answer. Yeah. And if you believe that that's wrong, that's fine, because my path is not your path. But my path is I'm going into the corporation and I'm going to challenge the corporation because I can, and I am a party to it because of my oath and obligation to do so.
Straight up. And that's
due to the violation and the lack of law is two-peer system that we have here. So, hey, I want to first, can I say something? Cam, good to see you again. And Mr. Downey, you're a godsend, buddy. I don't know what else to say, but you, good to meet you, and you've been godsend, and I support you in everything you do.
Glory to God, please. Yep.
I know we've gotten on a spiritual conversation here, but can any way of us getting back to the courts and you submitting your affidavits to the Supreme Court and our problems? See, because we can walk into the court and we can get out of our tickets because they don't have the jurisdiction. But when we go to get restitution for the atrocities that were brought against us, we are getting stopped at the court systems for submitting our affidavits or our complaints with course of actions, and we're getting them dismissed without probable cause.
Yeah. So the what I would say to that is that Over the last couple of years, I've gone around this country and I've been collecting affidavits from people who have been charged by way of information, not by indictment. Indictment is required by the Constitution of the United States. So Clause 1 of Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. Capital crime is any crime punishable by a death. That's pretty easy. Infamous crime is defined by Title 18, 4083 as any crime punishable by more than 1 year imprisonment in a penitentiary. So every felony and most gross misdemeanors is an infamous crime, requiring the infamous nature of the indictment by a grand jury before arresting you and holding you over for that offense. However, there are 13 states here in the United States that do not conduct a grand jury, including the state of Washington. Article 1, Section 26 of the Washington State's inferior constitution says no grand jury shall be drawn or summoned in any county. So now we have a state inferior constitutional provision that functions directly to contrary of the United States Constitution, and now we got a supremacy issue, right? But it's not just Washington. State of Connecticut doesn't conduct a grand jury. State of Pennsylvania does not conduct a grand jury. State of Michigan, North Dakota, South Dakota, Oklahoma. These are states that are acting in direct willful defiance of the procedures and processes codified in the Constitution of the United States for the adjudication of crime. As a result, there's more than 700,000 people currently imprisoned here in America on direct facial constitutional violations, meaning that there is no judgment that exists because the state failed to follow the very basic procedures and processes in the adjudication of crime the moment that they performed an arrest by relying upon an inferior state statute to deprive a person of something that's enumerated and guaranteed by the Constitution of the United States of America. That's a big deal. So, but now every other state, 13 don't conduct a grand jury, but every other state have written into their constitution, such as the state of Florida. Article 1, Section 18 says that the prosecuting attorney can charge by information or indictment by their discretion. Information can only be used as a charging instrument for non-infamous crimes. That's Title 18, 555. So when the state creates a law that directs their agents to disobey the law, or to abuse their discretionary authority with which they're invested in law to not fulfill the obligations that they have codified in the Constitution of the United States, that is a crime. It's called deprivation of rights under color of law.
Then emolument violation.
You're right. And so the emolument violation, what I'm doing now is I've been going around the country and I've been serving city council members, city council meetings. I've been doing hearings, also county commissioners, and I've been providing a notice to them. And so the emolument violation is when the state creates a law and then pays their agents to disobey the law, right? You cannot pay someone to disobey the law. So when the city council creates the budget that pays the law enforcement who are now arresting people without the proper charging instrument, now the city council is paying they are paying for these crimes, which now binds the city council and the legislative individuals there into this crime. But you got to go put it on notice. So I've been traveling the country, going to these city council meetings during a public hearing, and then stating, and these are available on my TikTok and Facebook. You guys are welcome to go out there. Have a whole bunch of services.
Hell yeah, my boy been putting in that real work, bro.
Most recently, the city of Boston, I was there and did the same. But you have 3 minutes to speak, and I informed them. Listen, you cannot pay someone to break the law. Constitution requires an indictment. The state of Massachusetts has enacted an inferior law that permits their agents to not have an indictment. Therefore, you are paying people to break the law. And I'm now standing here telling you that if you do not correct this unlawful act or stop paying them, that criminal sanctions can be brought against you. And oh, by the way, I have this 4-page notice that I want now put on the record. And now, city council members, you get to decide, are you going to knowingly and willingly engage in this criminal behavior that I've now informed you of? That's the city. Now the county, I'm going to those locations and serving them now, or providing notice in the same hearings, because they create and formulate the budget for the jails. They pay the sheriff. The sheriff are going out and arresting people because the judge told them to, and they're arresting without lawful authority because there's not an indictment in place. They're arresting on information. Now the county is paying for these crimes. But when you arrest someone and you hold them against their will without lawful authority, and you hold them for ransom in the form of bail in a jail, now guess what, county? You're paying for that jail, and that jail is now kidnapped and holding ransom victims of these crimes. So we're tying them in. So that's what I've been doing, going back and forth cross country, serving those. But the main affidavit is very simple. When a state creates a law and then substitutes that law for the guarantees of the Constitution, that's called sedition. Because sedition is defined as the speaking or writing of words such as law established in order to cause disaffection to the Constitution to procure its alteration in other than lawful manner. There's one way to change the Constitution. You go to Article 5, that'll tell you how to do it. Any other way is an act of sedition done by traitors to the nation. So when the state of Washington created a law that says prosecuting attorneys, you can charge by information because we're not going to conduct a grand jury, that prosecuting attorney has a duty and responsibility to make sure that the power that they exercise is consistent with their authority. If they choose to exercise their power by relying upon an inferior state statute to deprive a person of right guaranteed by the Constitution of the United States, they just committed the crime of deprivation of rights under color of law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. So when that prosecutor brings the incorrect charge and instrument to a judge and says to the judge, I'd like you to hold this person over, that judge also has a duty and responsibility. Make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the prosecutor's abuse of power, who relied upon the inferior state statute to deprive a person of right guaranteed by the Constitution, that judge is also now depriving of rights under color of law due to his negligence, but now he's established a conspiracy to deprive of rights, Title 18, subsection 241, which states when two or more persons conspire for the purpose of depriving any person of any right secured by the Constitution commits that crime.
Yep,
So
and
now
I'm
we have a
going after
conspiracy.
that one. I'm throwing that
Right.
one on my complaints.
So then when the
Oops,
judge issues an order and hands it down to a law enforcement officer and says, officer, go out and perform this arrest, that officer also has the duty and responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the judge's abuse power, who relied upon the prosecutor's abuse power, who relied upon the inferior state statute to deprive a person of right guaranteed by the Constitution, that officer is also depriving him of rights under color of law due to his negligence. He's a member of the criminal conspiracy, and the moment he goes out and performs that arrest without lawful authority, he has just committed the crime of kidnapping, and it is a federal kidnapping offense 1201 because they're holding the victim over for ransom in the form of bail. And anytime there's ransom, it is always a federal kidnapping offense. And now we have a situation where this is punishable by death, because anytime that you have a kidnapping that occurs in conjunction with the deprivation rights, the punishment as prescribed by law is always death. So I've went around the country and I've collected almost 2 million of these criminal affidavits, and we're preparing to deliver them to Supreme Court. Just to wrap your head around what this is, we have right now 13 pallets, right? Each with 40 boxes of paper. That's how much we are getting ready to deliver to the Supreme Court.
Where's it
13
at?
pallets.
Where's it at? Is it right on your Facebook?
What's that, the affidavit?
Where you're pulling out, where you're pulling them all out on the floor and you
So yeah, that was about 70,000 of them. That's just one bin. That's on my Facebook page. I think it's on my TikTok page too. It's like within the last week, but that's only 70,000 that we pulled out of one bin. I'm gonna tell you guys, we have 2 million in 2 secured locations here in the United States that we are preparing. We've reached out to the Supreme Court. We've reached out to the clerk this last week, and we let them know that we have 13 pallets that we need to deliver to you. They bulked at it and said, well, we don't have the ability to warehouse that. And I said, well, we can do it one at a time if you would prefer from your guard shack, but that's going to mean that we're going to tie your guards up for the next 4 days if that's what you would like to do. But you have to receive all these. So we're asking them to give us the time to be able to deliver this evidence, but we have 13 pallets that are ready to go to deliver this final blow to that court, and they get to decide, are they going to correct the unlawful acts of their agents who they are now responsible for because the judges and prosecutors all work under their edict, or are they going to become members of a criminal conspiracy due to their negligence? And that's up to them now. So this is roughly 70,000 as I pulled them all out of the bin here. That's just one bin that I had in the back of the car. We can't even carry one pallet in the car that we're in. So 13 pallets is what we have right now.
I guess if you're going to cite statute, policy, and code, you better hope they don't turn around and do the same thing and call you a paper terrorist. Because,
I mean,
either way, people in jail now for 10, 20 years for apparently being paper terrorists. So however that works.
This is the people talking, and that's what's beautiful about this, man. And I really commend you for all the work that you've been doing, bro. It's really beautiful, and I think everybody should just unmute and thank Tanawah for actually putting in this work and gathering the people in such a manner.
Dude. I've been following you a long time now.
Thank you, Tanawah. Hey, I've been wanting to ask Tanawah a question.
Yeah, offense is definitely the way to go.
Thank you, Tanawah, immensely.
Yeah. Yeah.
Thank you, Tanawah. Always remember, we the people.
Hey, I wanted to ask Tanawah.
Again, we appreciate everything you're doing.
I
So
appreciate it,
Cameron,
guys.
Cameron, I let me be clear because I don't want it to seem like I have an issue with the man. What's Tanawah's first name or given name?
Yeah.
Tanawah.
Yeah, so I appreciate your time, energy, and attention. It seems like you're motivated, and you're putting in a lot of work or steps on the ground. You know, I just try to keep it simple and what makes sense and what I see as the purest idea here. And I believe that at your core, you have the same. It's interesting because this is what I was talking with. Yeah, this is what I was talking with Cameron about, right? So I'm not necessarily down on the way, because we're all choosing and it's going to create an experience and we're going to learn from that either way.
Yeah.
But I just believe that we've all kind of been indoctrinated or institutionalized into this idea that we don't have power with the core of who and what we are in the word, and the purity of intention. And I found the opposite to be true. So I guess what it just comes down to is we're probably not going to necessarily see eye to eye right now.
Well, what? It's okay, and check it. What I'll say
Yeah,
about
it's supposed to be both, man. We're supposed to do both.
Yeah, and what you'll notice is coming into the Wisedome, if you come around just a little bit more, you'll tap in to see that there's a source that's being created that is unstoppable right now. It's like we got like you got your own family, we got our own family, and it's like everybody in this Discord definitely helping each other. And it's become everybody paying attention to everybody else's situation and figuring out how we can help.
Yeah.
Because everybody's moving forward with their civil suits in their own way for the first time, right?
As power like no other, Cam.
Yeah, and that's what's really cool is again the knowledge aspect is bringing that empowerment, which is bringing unification again, and it's not in that belligerent manner; it's in that intellectual manner, right? Like we are of the higher essence, and we seek the rest of the nation to follow and such, right? Be a leader, and men will follow, and women will follow. Women love a strong man that already knows his goals and intentions in life, and if it's to empower others and to become great in life, to see that their children do better, like what better mission do you have from the great creator than that? Yes, ma'am.
Tanawah, I just want to give a statement from earlier. I agree, and I hope there's 1,000 more people like you that come and join what you're doing. The reason my disagreement about the creation of federal government comes from the Constitutional Convention, which was a convention of the states that created the federal government. I just wanted to explain that.
Yeah, yeah.
I hope you can find 1,000 more people like you and 1,000 more added on to that, because you have got a lot here to help bring back our Declaration of Independence that guarantee our rights.
Yeah.
Tanawah, I recall you want some volunteers on your website. Could you tell us some more about that?
Yeah. So, I'll hit that just one moment here, but there's two things I want to say. One is that that I know that we're all on a different path, right? And I don't have any problem with other people's approach. You know, I don't necessarily agree with the sovereign approach because
You're getting cut off here, Vampiro. You're cutting him off.
Thank you, Paul. I was about to say that.
So the thing for me is that I believe that we live in a. Oh, okay. So I believe we live in a communal society and that we need to give up certain rights in order to accept the greater good of the whole. That's the path that God put me on, but I would never ever say that someone else is on the wrong path. But what I want
that's precisely what it's interesting that this is, and again, I'm so open to having a contention point here in order to get to truth, but I don't want it to seem like I came in to take the wind out of sails and try to demean or devalue and then get into some argument like Wesley.
You're good, bro. We're past that.
Yeah.
Wesley's like, dude, seriously, you need to back yourself
we're
up
past
and listen. So it's like, from my experience in my walk, I'm somebody who I've not complied. I've not cooperated. I've been arrested over and over again, right? I've had to go to court without an attorney, with no credentials, and stand on what I believe to be the word of God and the truth. And I've gotten results. So I don't know Mr. Tanawah's history. Tends to be when I meet people who talk about this what I consider to be false ideology of patriotism they've been uploaded with. Usually, I don't know, there's someone coming in and out, there's feedback there, Vampiro, whoever it is. Usually these are the same folks who tell me we're very courageous, we want to save the children, we're going to be idols and heroes, but they're not willing to sacrifice and go to jail and be activists and potentially have to sacrifice and give everything up to be given everything back.
That's unfortunate.
So,
and
not
it is
ours
true.
to judge, bro.
And that is true. And that's
not ours to judge, though. It's not ours to judge.
Right,
and
I'm
that's
not
true.
making, I'm not making a judgment. I can't make
Right.
a judgment. I'm
Good.
not God, and that's precisely the point. I'm not trying to step in for God, and I'm
Good,
not
then we're
agreeing
past that too. Then we're past
Right.
that
So
too.
there's
Good
a
deal.
difference between discernment and judgment. And discernment is when you look at what people do and you make a determination on how intent and pure they are and what they're actually trying to achieve versus what they say. So part of the deception and the deceiver and a collectivist dynamic is people look at what's being said rather than watch what people do and don't do.
Yeah.
It's why folks
Yeah.
keep getting misled by presidents and vice presidents and all the rest of it. So he just stated who and what he is at his core. He doesn't believe that we have an ability to have natural rights without giving them
No,
up for a collective.
that's not what I said. Don't put words in my mouth, because that's not at all what I said.
Yeah, that's not what he said.
I'm not trying to put words in your mouth, but I thought you just said.
No, what I said
I
is
believe
that
we have to give up rights.
I believe that we live in a communal society, and in living in that communal society, we need to give up certain rights for the greater good of the whole, because that's what a communal society does. That's what the Constitution is. We give up certain rights in order to be able to live peacefully amongst a communal society. You see, I'm not subject to laws.
Why would we have to give up rights to live
Shut up!
peacefully?
Really?
He's trying to say this, what I've been trying to say for a while now. In the preamble, in the Constitution, the Declaration of Independence, we, the people, in order to form a more perfect union.
You don't need to yell.
That's what it's all about. I'm sorry.
Damn, Wesley.
I've been hearing this crap.
But do you see the way that you guys present and even sort of react and respond when you're given the slightest bit of question and answer and pushback? You start getting emotional. You start making
but that wasn't
faces.
a question. You were putting words into my mouth, and that's not. So
You
I'm
literally
not.
just made the statement we have to give up some rights in order to be part of a communal society, with the presumption that we live in something you call a communal society.
So
I don't know
unfortunately
what
for
that
you,
means. You have to define it.
Unfortunately for you, you don't understand where laws come from or where our Constitution comes from, because it came from what's called a social compact theory. And in the social compact theory, right, starting with cavemen, in the caveman days, only the strong survived. So did you know that as a caveman, you have the right to kill someone, right? You have the right to steal from someone, because in the natural state of man, only the strong survived. So in order to have rights, we have to give up rights. If I have the right to kill, in order to have the right to live, I must give up my right to kill. Thus, a law is created. Yes, we have to give up certain rights that are not desirable so we can preserve certain rights, that certain things that would not be natural in the natural state of man. That's what a law does. So yes, you must give up certain rights, your right to kill, or your right to assault, or your right to steal, or your assault, or your right to rape. Those are not rights that we as a human society want to have, and yet in the natural state of man, we do. So we give up the right in order to have a communal society.
So we
That's
give up
the
the
rights
right
that I'm
to
referring
kill
to.
and
And
rape.
those are what I'm talking about. And I would appreciate it if you don't put words in my mouth. Just so that you know, 9 years ago, I was on the other side. I made $870,000 a year because I worked for them. 9 years ago, I decided to go into civil rights litigation full time. I haven't been paid a cent in 9 years because these people need help. So when you talk about whatever it is that you are referring to and how words and actions and sacrifice don't exist, I'm going to tell you right now, I don't know anyone who has sacrificed what I've had to sacrifice to do what I'm doing because I care about this country and I'm going to fight for this country, even with people that don't believe in it, because my faith is strong enough to get me through it.
We have to have
I know your
guidelines.
sacrifice.
As humans, we have to have guidelines. Otherwise, we get out of control. So there has to be certain regulations in order to guide us and keep us in check.
That's conscience. It's you know, it might be theoretical, but one could presume that every being has a conscience, and self-governance emanates from that conscience. The self-governance doesn't emanate from code on paper. So I don't know where
Hold on a second. Hold on. All the masculine energy, hold on 1 second. Let's just calm down and let us all take a deep breath.
Right, that's not masculine energy,
big,
because the man just said
wait.
fight, but all he's willing to do is talk and follow
Excuse me,
code.
sir. Excuse me. Big Mama is here now. Let us take a
Well,
deep
that's
breath.
the thing.
Excuse me, sir. Excuse me.
So other folks get to go on and on for
me.
3 to 5 minutes, and then I'm going to get cut off and ganged up on because
Excuse
I'm
me.
questioning and positing different.
Hey, bro, you keep interrupting people, and it's really disrespectful. So calm down.
Right. So because when you lay 3 or 4 or 5 concepts out rapid fire, we kind of got to take them one at a time so we can get an understanding of what we're talking about here, right? I'm not interrupting to be authoritative or to try to interfere with his right to speak. I'm trying to get a handle on the first, second, and third conceptualization he's laying out and how it's aligned, right? So like he just made us.
You've been attacking this man for the whole doggone thing.
I'm not attacking him.
Yes,
I'm not
you are.
attacking.
I'm leaving. Bye.
Yes, you are.
Okay, so we're
No,
getting
not
emotional.
be in your heart,
So we're
but it's
getting
perceived that
emotional. We're
way.
acting out. We're grouping up. This is exactly why.
And you're being belligerent.
Hey,
I'm being belligerent. Okay. This is exactly why. This is exactly why democracy and collectivism and everything else hasn't worked and doesn't work.
Everybody has.
This is why we need.
Can I ask a question? May I please ask a question? Can I ask a question?
And please mute everybody and hands up.
Nah, it's okay. I think what's very cool here is, again, like what I've done is I've allowed myself to realize that I gotta let God, or I gotta give myself up more to the situation and stop controlling things as much. I found myself trying to control things too much, and it was just stressful. I kind of just allow things to
Can I
play
ask a
out as
question?
they are a little bit. Wait, if I could finish what I'm stating, then that would be cool.
For sure.
But, like, don't interrupt me. So like what's going on is I am a little upset that the conversation has transpired and gone this way. Just because, you know, there's so much that someone does, and I find myself maybe getting into the situation and of course having to deal with things like this, and it's all for a good cause. It's all for my children, honestly, and then my grandchildren, and of course that extends out to the world. Just because I realize this reality is pretty wild, and with all that work, people really try to do the best that they can to just change what's, at least on the mainstream level, and hope for the best. And I think Tanawah's purpose and drive is, bar none, one of the most exciting that I've seen out here in regards to standing up for our rights. And I so commend that, and I so appreciate everything that he's doing. And I think he deserves nothing but the utmost respect and gratitude for the work that he's putting in the community.
I'm with you, Kim.
And that's all I'm gonna say about that. So.
Yeah.
I don't understand what's so hard to recognize that both people are exactly right. Dunslaved is dead on, because when you get in as the individual and you're on your own, you know, you follow that method or something truly akin to it. We all then go ahead and believe that inside our souls. So we're really not fighting over anything except our passion to love the other guy. That's what's so funny about all this. And then Tanawah is exactly right, because I'm totally behind him half the time. I just want to sell my house and volunteer and go like Tanawah. I'll be a sort of groupie and can follow behind and let's go fight these bastards. That swells up in my heart. I love that in me. God gave that to me. I'm perfect. So that must be right, because it always swells up in me. So we're both right. Everyone's right. I don't know why. We don't have to get too hard on all this stuff. I do want to hear the rest of Tanawah's presentation, because I know he's wrapping up. And I totally want to hear Dunslave Slaved, if I got that right. Pitch
Unslaved.
exactly what he does. Unslaved. I missed it.
Columbo
Well, I think,
Gorilla.
But
well,
I totally want to hear him
at this
pitch his
point,
way.
Tanawah has exited the building, and at this point, well, I'm going to
Cameron.
I'm going to end the YouTube stream. So everybody just say bye to YouTube.
Bye, YouTube.
Bye, YouTube.
Bye,
Bye,
YouTube.
YouTube.
Thank you.
Sayonara.
So
Shit.